All right, all right, all right. It looks like we are live. Welcome back to yet another BriHive live stream. I have missed streaming this week. It's been a long week. Let me know how you guys are doing in the chat. And if you're on the replay, go ahead and drop in the comment section, letting me know that you are watching on the replay crew. Now, today we have some updates in some cases that we covered before, but I also saw that there was some new information in some other cases that we covered some more, but we're not going to quite get to that today. Today, we are going to be covering Netflix's motion to dismiss the baby reindeer lawsuit. And surprisingly, or I guess not surprisingly, they do touch on a couple of topics that we touched on last week. Saying that touched on threw me off, but that we touched on last week in our reasoning as to why we don't think that Miss Fiona Harvey is going to win on her claims for defamation and the IIED and then the negligence, which had some good arguments that I wasn't really expecting. So they taught me a little bit of that. Thank you, Netflix, for that, or Netflix lawyers for that. And then we are also going to jump into what's her name, Ashley Benefield's motion for a new trial, motion to dismiss the judge, motion to interview the jury, motion to motion. She filed a lot of motions at the end of the case. So we're going to jump into a couple of those. I know they came out probably almost like a week ago, but we're still going to cover it and see what's going on over there with Ashley Benefield case. If you don't remember that case, that's the one where the lady unalived her husband and claimed self-defense. We briefly covered it on this channel. We covered the verdict, and then I think we did like the first day or something like that. Or so I think we did some of her testimony. But anyway, she was found guilty of manslaughter, I want to say. And she's basically like, no, I should have no because of self-defense. Y'all should not have convicted me. We really shouldn't have even tried the case. And the jury was doing some messed up things. The judge was doing some messed up things. So I want out of this. So we're going to jump into that a little bit later. So if you are here live, go ahead and drop in the comments or in the chat, letting us know that you're here live. And I'm going to go ahead and say hello to all. We are currently at 10 likes with 8 people watching live. So we are doing phenomenal. But if you haven't hit the like button, please do. It does help out the algae. It helps out the algorithm, and it does help us get more friends to the channel. So with all that being said, let's see Bossy B, because my girl is hibernating. All right. Let's see who is here live. We got Phoenix Waller, a member of the channel. Hello and welcome in. Saying, watching the latest Sahih video about Janet while waiting for the live to start. And man, we all know Janet is garbage, but I'm still getting the ick. There's some new stuff in Jeanette Braun and Lauren the Mortician. Did not know it, so I am going to need to take a peek in that. So let me go ahead and get my little list started. I got to go check out Donald Adelson. I got to go check out the TikTok lawsuit and any other lawsuits that y'all want to go ahead and throw out. I know I should have posted it on the community tab, but I did post on Discord for those of you that are not a part of the Discord, what cases that you guys wanted to cover today. So if you're not in the Discord, make sure you join the Discord and be there so you can let us know what cases are popping and what cases you want to hear the BriHive Chat's opinion on. So I have a link and I'm going to ask Kimmy to share it for me because I cannot, multitask and things like that. So Kimmy, when you get a chance, can you drop the link for Discord so that the people that are not a part of the Discord can join? We got Chelsea B, another member of the channel, saying, hey, everyone, hello and welcome in. Nice to see you tonight. We got Fiona Davies giving us a wave. You got the same name as, baby reindeer, Fiona Harvey, but your last name is Davies. Oh, that's pretty close, though. That is pretty close. Hello and welcome in. Nice to have you in. We see John Smith. He doesn't like his things read. We got Island saying, hey, y'all, hello and welcome in. Nice to have you back on the live stream. We got Kimmy Locker, our member, our moderator, our consultant, our paralegal of the channel. Shout out to Kimmy because she grabbed all the documents for us. Hello and welcome into the live stream chat and also backstage, and also drop in the Discord link when you get a time. Welcome back to the live stream. We got Z Seltzer, another member of the channel, saying hi with a waving pink hand, dropping a BriHive emoji. Hello and welcome in. Nice to have you back tonight. Have you been in the live stream in a while? I feel like I haven't seen you in a while, but I could just be misremembering, because if I told y'all about the life that I have been having in the law firm, in the working world, right? Not on the YouTube world, the life that I have been having and that has been kicking my freaking butt. So I'm tired. So sorry if I don't remember things. And sorry if I'm not as energetic, but that's okay. We're going to snap back once we're getting some slowdown. So we're going to snap back and have the good BriHive live streams coming up here. And Kimmy went ahead and dropped the Discord link and pinned it to the top of the chat. So again, if you're not in the Discord, go ahead and drop it. Or sorry, go ahead and join it if you have Discord. We got Destined to Be, also known as Tanya D, saying, hey, dropping a BriHive emoji. Member and moderator of the channel. Welcome back. Nice to have you here live tonight. Hope you are doing well. Hope you got some more orders. Phoenix Waller says, what about Lauren is Janet specifically in a cosmetic company? Oh gosh, something else? Is it a new lawsuit? Oh geez, Louise. Doodle Noise, another member of the channel. Hello and welcome back, saying hi. Happy to be with BriHive Live. Hello and welcome in. Nice to have you back tonight. We are happy to have you in. Kimmy Locker dropped the Discord server link. So again, guys, if you're not part of Discord, go ahead and join it and join our little channel we got here. Thank you, Kimmy, for that. And then we got Destin to Be saying, good to see you, to Doodle Noise. All right, y'all. We are going to jump right into Baby Reindeer's motion to dismiss. There is also a motion to strike under anti-SLAPP, and I did not have time to review that before the live stream, so we are not going to be covering it on the live stream. I may figure it out a little bit later on. And mind you guys, these motions have happened a little while ago. I'm just now catching up on the case, so that's why we're just now covering these things. So hopefully I said hopefully, but guess what? We're going to have a hearing on this on September 3rd. So we're going to be able to update on it next week. So that's pretty exciting. Okay. This is for September 3rd for the motion to dismiss. So we'll know if Baby Reindeer lawsuit is going away. And I think that Netflix made some really good points, but I forgot to swoop. So we are about to have Bossy B bring us in. Okay, so let me do my spiel again, okay? We have a Baby Reindeer. This is the case where the lady Fiona Harvey is suing Netflix and Netflix Worldwide Entertainment, just Netflix all around, for producing the series document or the limited series Baby Reindeer that was written by Richard Gadd. And in that series, Richard Gadd basically tells a story based on his true life about an incident that he experienced with a so-called stalker named Martha, and his character name was Donnie. And then the people on the internet went and found a tweet from Fiona Harvey and asked her, are you the real Martha from Baby Reindeer? And Fiona, instead of being like, a smart lawyer and being like, nah, that's not me, she was like, yes, it is me. And by the way, I am going to go on a talk show and tell y'all all about how it is me. And now she's suing, alleging that she suffered damages because people know that Martha is Fiona, okay? But the only reason why people know that Martha is allegedly, and again, they have not necessarily admitted that Martha was Fiona, but the reason why we even think that Fiona is Martha, because Fiona says she is Martha, okay? So any emotional distress, Netflix said you brought it onto yourself. You should have just been quiet. No one would have known it was you. So let's go ahead and jump into the motion to dismiss. We covered the complaint last week where she alleged defamation for basically smearing her name. And there's some juicy details as to why the court should not consider this defamation and consider the Fiona, the plaintiff, to be what do they call it? An unliable, or what do you call it? Let me see what it's called. She is I forgot what it is. Basically, you can't defame her because she already has so much defame going on that you can't ruin her reputation anymore. I forgot what they call it, unslanderable. No, it is not what it's called. But they basically say, no, she should not be seen as, not the perfect, but I don't even know what I'm trying to say. She should not be a plaintiff in this case because she's already been doing messed up stuff that messed up her reputation in the past. Kind of like, Samantha Markle, maybe. I don't know. No, maybe not. Maybe I'm jumping to conclusions. But anyways, Netflix just came and they were throwing shots. They throwing shots as to why this case should not be going forward. So let's go ahead and jump. Oh, I I forgot to say, she alleged defamation. Never mind. It's going to say it in the complaint. So let's jump into it. Bri, you actually have to put the document on the freaking stage. Come on, girl. I know it's been a week, but hasn't been that long. Let me see. I don't want to cover. Okay. Yes, we're going to cover the whole introduction. Okay. Again, this is the motion to dismiss the complaint mainly regarding defamation, but they do also touch on the other claims that Fiona Harvey is alleging as her being Martha suing Baby Reindeer series. So the defendant Netflix Inc. and Netflix Worldwide Entertainment create and distribute artistic content globally. Netflix provides storytellers like Richard Gadd, the creator of and lead actor in Baby Reindeer, the opportunity to display their creative works. The series, based on real events in Gadd's life, follows the character Donnie Dunn, an inspiring comedian who struggles with his sexual identity and past sexual abuse. Another character, Martha Scott, stalks, harasses, and physically assaults Donnie, forcing him to confront his insecurities. Well before the series was released, plaintiff Fiona Harvey, get this, y'all, plaintiff Fiona Harvey was publicly accused of stalking and harassing Scottish attorney Laura Ray. So she's already stalking people, okay? She was also accused of publicly stalking and harassing the wife of Labour Party member of Parliament Jimmy Ray, and that's who Laura Ray is. And also a politician named Donald Dewar, I think you say it like that, the integral First Minister of Scotland. She's stalking the First Minister of Scotland, inaugural First Minister of Scotland. Girl. Okay. After the series release and the critical acclaim, Harvey came forward to claim the character. Let me get my reading together, y'all. After the series release and critical acclaim, Harvey came forward to claim the character Martha was actually her. Harvey asserts defamation, intentional infliction of emotional distress, negligence, gross negligence, and a right of publicity claims against Netflix. Netflix's concurrently filed special motion to strike seeks to strike Harvey's complaint in its entirety, as she cannot establish the required minimal merit to overcome the protections provided by California's anti-strategic lawsuit against public participation, also known as anti-SLAPP. That said, Harvey's claim also failed at the pleading level, as explained in this motion to dismiss. Harvey's defamation claim fails because she does not allege a provably false statement of fact was made about her. Remember, we touched on this a lot. It's called a libel proof. Thank you, Kimmy. I completely forgot what it was called. We touched on this on the complaint. Is it defamation? Because did we really know the comments were about her other than when the internet sleuths went and found her and then she confirmed, yes, actually, I am Martha. Martha is me. Could we really establish that those statements were made about him? Can we assume? Can we kind of, excuse me, y'all. Can we guess? Could we have kind of perceived it? Could we have inferred that these statements were about Fiona? Maybe, maybe not. Well, a lot of people don't know you, Fiona. A lot of people don't know you. But maybe in Scotland, they could have perceived it to be her. But in America, I don't know about that, girl. But anyways, let's go on. Okay, so in fact, Harvey is incapable of showing reputational harm. Her reputation was already tarnished by past news stories detailing her previous harassment and stalking of public figures. It's almost like she's thriving on stalking people and getting famous for it, right? And as a public figure herself, she must allege actual malice. I don't know why they're saying she's a public figure, other than that she has been publicly accused of stalking people in the past. And also that she inserted herself into the limelight. I think that's what they're accusing her of, but they also don't go into much detail about that part of why they're saying she's a public figure and needs to prove actual malice, unless I just forgot when I was reading it. She does not even attempt to do so. Her defamation claims thus fails, as do the rest of her derivative claims, each of which also independently fails for the following reasons. First, Harvey fails to sufficiently allege intentional infliction of emotional distress because she does not allege Netflix engaged in outrageous conduct, nor does she plausibly allege causation, as even if Harvey did suffer emotional distress, Harvey, not Netflix, caused it. She put herself in the limelight. The series never mentions Harvey. Harvey became news only after she proclaimed she was the supposed inspiration for the Martha character. Any supposed harm was caused by Harvey and Harvey alone. Second, Harvey's negligence and gross negligent claims fell because Netflix does not owe her a legal duty separate from the duty not to defame, which is subsumed in Harvey's defamation allegations. And remember, we talked about this with the complaint as well. I was like, I don't know how she's going to claim a duty. What duty does Netflix owe to her? Netflix is saying the only duty that they owe to her is not to defame her. And since they never mentioned her and reasonable people could not infer it was her, we did not defame her, okay? And they're saying under no other theory could she prove duty to Netflix to her. In any event, if a supposed legal duty and negligence exists here, and it does not, Harvey cannot sufficiently allege breach. A disclaimer appears in every single episode indicating the series is fictionalized for dramatic purposes, and her name appears nowhere in the series. This clear notice only reinforces the care Netflix took to ensure the series' fictionalized characters were not associated with real individuals. Harvey also fails to adequately allege causation. Again, she is the cause of any purported harm. She put herself out there and claimed to be Martha. Again, we touched on this during the complaint as well, as far as what was it? I completely lost my train of thought yet, y'all. I forgot. I lost my train of thought, so maybe it'll come back to me. And then third, Harvey's right to publicity claims fail because the series is an expressive work protected by the First Amendment. They also separately fall they put fall, so I wasn't wrong. And they also fail because Harvey fails to plausibly allege that Netflix used her identity, much less that it would have been to Netflix commercial advantage to do so. Who is this lady? Why would we want to write a story about her, essentially? Finally, Harvey's request for punitive damages fails because she does not sufficiently allege fraud, oppression, or malice. All of Harvey's claims should be dismissed. That said, as detailed extensively in Netflix concurrently filed motion to strike, and as demonstrated by the accompanying evidence and declarations in support of Harvey's claim, are completely barred by anti-SLAPP statute. As such, Netflix respectfully requests for judicial economy that the court determine the merits of the motion to strike before ruling on Netflix's motion to dismiss. So basically, at the same time, they're saying just get rid of the case by saying this is not a valid case, or if you don't do that, then dismiss it because she failed to state a claim. So those are the two options, two theories that Netflix is moving to get this dismissed under. I am going to skip over the background of who Fiona Harvey is because they kind of go into it during the argument portions of things. And then with the series, I'm also going to skip over that because it just kind of gives like a summary of what happened in the case, which is he's playing himself as Donnie, and then Martha, allegedly Fiona, is crying. He gives her a free drink. Then she starts harassing and stalking him and all of the things. And they go through the whole series. If you guys want to know what happens, watch the series. I haven't yet, but I'm telling y'all to do it. Okay. And then Fiona goes on Piers Morgan's interview for an hour. She went and talked about this for 1 hour. Okay. And then we got Harvey allegations allege that all viewers of the series concluded she did monstrous things Martha in the series and Martha does in the series in real life, basically saying everything that Martha did, she's being accused of doing by random people on the internet. Yet she concedes that her name does not appear in the series. There are no characters named after real persons, and the dramatic scenes and content were created to make the story emotionally compelling. Harvey further concedes that the series' portrayal of Martha is entirely fabricated. She acknowledges that Gad and Netflix sought to disguise any real persons who served as inspiration for Gad's for Gad in creating the series. In addition to her defamation claim, Harvey asserts claims for intentional infliction of emotional distress, negligence, gross negligence, and violations of common law and statutory right to publicity, each of which is based on the same allegations as defamation. So we are going through a motion to dismiss, failure to state a claim. The court has to consider the facts as if they were true, except for if they contradict any like legal things, right? So let's see why Harvey's claims should be dismissed. And that's what I wanted to go back to. And I feel like it's slipping my mind again. Oh, it slipped my mind again. I was reminded and then I forgot. So that one's gone. Hopefully it comes back again. Oh, that's what it was. The real big part that we kind of focused on last week on the complaint is that it was saying that, or Martha highlighted that it says, this is a true story. But Netflix made sure to say, but every single episode says this has been dramatized, fictionalized, so that not to relate to any person for the purpose of the TV show. So not only it said a true story in the beginning, but it also had a disclaimer every episode, basically contradicting that it's a true story. And then at the end, it goes, this is based on a true story. So that's one thing that I wanted to point out there. Let's jump into why Netflix is saying that Harvey's claims should be dismissed. Harvey fails to adequately allege defamation. As detailed in Netflix concurrently filed motion to strike, Harvey cannot establish that her defamation claim is legally sufficient and substantiated. The claim is also not sufficiently pled for 4 independent reasons. She fails to adequately allege that the series makes any provable false statements or fact about her. Thus, Two, the alleged defamatory statements constitute legally protected opinion. 3, Harvey is a libel-proof plaintiff. And 4, Harvey fails to allege actual malice because they're saying that she is a public figure. Maybe I skipped that paragraph because I was running out of time. So we'll look at that when we get there. So statements first reason why they're saying that it fails. Harvey fails to allege a provably false statement of fact. Statements cannot form the basis of defamation action if they cannot reasonably be interpreted as stating actual facts about an individual. Courts consider whether a reasonable person would understand that the fictional character therein pictured was, in actual fact, the plaintiff acting as described. They looked at a case looking at the totality of the circumstances, including the broader context. Here, the alleged statements occur amidst dramatic and cinematic devices. Moreover, Harvey does not allege the series uses her name any person from her real life, or depicts any real events. See generally the complaint. In such context, no reasonable viewer could understand the series to somehow convey statements of fact about Harvey. They didn't even say her name. So how are you going to say that this is defamation, right? It has to be a fact, something that you can prove is false. And it has to be about her. We would have had to know about what's her name, Fiona, going into this bar where Gad worked and him offering her a free drink. And we would have to know all of that without her telling us, hey, it's me. This is who he's talking about. He gave me a free drink before. Look at us. Maybe there's a lot of weirdos. We talked about this. Maybe there's a lot of weirdos in the area that he gives free drinks to. So let me not call her a weirdo. That's not nice. Anyways, let's go on. Harvey's lament in internet. Harvey's lament that internet sleuth supposedly identified her from a single tweet from a decade ago sent from an account Fiona Harvey 2014 to Mr. Richard Gad, that this tweet made her easy for the public to identify. I agree with that. I didn't think about this when we covered this last week, but it was one singular tweet from like 10 years ago. Maybe they just typed in curtains. Maybe they just typed in curtains on his to search his Twitter. I don't know if you can even do that, but they ended up finding her from a tweet from 10 years ago. I think Netflix is onto something by saying that. Like, that's unreasonable to just assume that's the person. The other thing we have to realize is she then confirmed, yes, it is me. So, I mean, it could be, or maybe there's multiple people that he talked to about hanging curtains, or maybe the person actually said what I said last week of like, oh, come make my bed. And he changed it to curtains. And she just happened to tweet him about curtains. And it's really not even about her. Who knows? Who freaking knows, right? Let's go on. Where are we at? Okay. So let me just go back. A singular tweet that the tweet made her easy for the public to identify and that broad similarities exist between her and the Martha character. Do not plausibly allege that the series is of and concerning her. After all, the legal test is whether reasonable viewers, not a specialized audience, would understand the character Martha acted as Harvey did in real life. Specialized audience not representative of a reasonable person. Further, a mere similarity is insufficient to establish work of fiction is or of concerning a real person, especially where Harvey necessarily admits Martha is fabricated. And members of the public have speculated that several other women and a man may have been inspiration for the Martha character. So, in what can happen in these type of these type of series is maybe they draw from a bunch of different experiences that they've had, right? And maybe he read about her in the newspaper and was like, oh yeah, let me just give her that background, and then this incident happened with this person, so let me throw that one in there, and this incident happened with that person, so let me throw that in there. So other people are speculating that it was other people that he is basing the character on, or it could be based on no one at all. Who freaking knows, right? Even if a reasonable viewer would somehow understand the statements to be of and concerning her, Harvey nonetheless still fails to plausibly allege that a reasonable viewer would understand the statements in the series replete with over-the-top cinematic elements to be literally factual, especially in the light of the disclaimer appearing in every episode. No reasonable viewer would understand film as a conveying objective fact given disclaimers. Let's see. Each alleged defamatory statement is presented in the context of stylistic cinematic choices that reaffirm for the viewer that the series is not a precise portrayal of historic facts. This is from a case. Use of rhetoric negates impression effect. Context not factual where comedic devices frame statements, and then statements not factual were made in an unhinged character. So those are from case law. In short, the general context and content of the series demonstrate that no reasonable viewer could understand it as making a statement of fact about Harvey. Again, I agree with it. I don't think that a reasonable person would automatically assume, oh, this is about Harvey, right? You kind of have to be known in that realm, right? Of people that, and that's a huge realm when we're talking about 56 million people, and you go through, oh, who was Martha based on? You're probably going to have 80% of people saying, oh, this is completely fictional. It's not based on anyone. Or maybe it's based on someone, but we don't know who it is. And then you see there was allegations that it was more than one woman, and that it may have been a man or whatever it may be. There's so many different things versus like if you watch a TV show and they put a black president. I gave this example last time. They put a black president there, and they give him this deep voice. We're going to assume that's an Obama portrayal, right? If we're watching SNL Live, is that what it's called? Whatever. And they got a skinny man, black, and he's the president. We're going to assume that's Obama, right? But not necessarily if you get a chubby lady with dark hair that is, a lawyer. We might assume that's a lot of people, right? Because there's probably a lot of people that are like that in that industry. So, I mean, I guess unless she's like a famous lawyer, and I guess because she's known for stalking people, I guess that could be an argument. She's known for stalking people, so maybe people would assume that. But also, if you're not from Scotland, would you even know of her? And this is premiering, I would assume, mostly in America, and that's where she's suing. I mean, because I guess the Netflix is from California, so I guess. But anyways, I don't think a lot of people would draw that it is her. So let me know what y'all think in the chat. And y'all, I'm stumbling already. I don't know if I make it through the live stream. I'm like so tired. I can like barely move my mouth. But anyways, let's jump back into it. The alleged defamatory statements are not actionable. Netflix's presentation of Gad's story is legally protected opinion. The law protects Gad's right to tell his story his way. The First Amendment protects an author writing about a controversial occurrence who fairly describes the general events involved and offers his personal perspective about some of the ambiguity possibilities and disputed facts. And we talked about this on the last live stream. If I tell a story and you were there, your story might be different than mine because it's how we perceive it. So Netflix did a good job of, throwing the laws to support it in there. Thank you, Netflix, for basically explaining how these things work. And hopefully Fiona won't sue for the same thing in the future. Okay. And hopefully Netflix is right while I'm giving them all this praise. So crucially, where the storyteller was personally involved in the controversial story, viewers thus fully expect that the storyteller is biased and preferential to his own viewpoint. Absolutely true. You're the one telling the story. You're going to tell it from your side, right? In such circumstances, language which generally might be considered as statements of fact may well assume that the character's of statement of opinion. Exactly. This is how I viewed it. Next reason why they say that the defamation claim fails. Harvey is a libel-proof plaintiff. Why is she libel-proof? You cannot say bad things about her. Under the libel-proof doctrine, a plaintiff's reputation with respect to a specific subject may be so badly tarnished that he cannot be further injured by allegedly false statements on that subject. From a case, if the individual general reputation is bad, he is libel-proof on all matters. God dang. So if you are accused of stealing a baby giraffe and somebody say you stole some candy from a candy store, that's not defamation. You stole a baby giraffe. You want us to believe you didn't steal candy from a candy store? No, you stole that baby and you stole that candy. I don't know where I come up with these examples. Why a baby giraffe? That makes no sense. But you guys get my point, right? If you are bold enough to build a bear, if you are bold enough to steal a baby giraffe, stealing a little candy from a convenience store is not above you, okay? It's just not above you at that point. Let's go on. We got Harvey fits the bill of a libel-proof plaintiff. She was publicly accused of stalking Scottish attorney Ray and politician Dewar. The public accusation made against her included, but were not limited to, threatening Ray's law firm and staff to the extent she had to issue them panic alarm threatening Ray's law firm and staff to the extent she had to issue them panic alarms due to their fright. Also, the lawyer had to give her own staff panic alarms just in case Harvey came in. That's sad. Threatening Ray and her husband, including leaving messages on their answering machine saying, "I'm going to get you." I'm not trying to laugh, but it's kind of funny. "I'm going to get you." And otherwise issuing death threats. Third, falsely accusing Ray and her husband of abusing their disabled son. 4, showing up at Dewar's surgery and shouting, swearing, and calling him names. And 5, telling a London-based Black female candidate for the Glasgow Cathcart parliamentary I can't speak nomination that she had been willed in the last minute by men in Cathcart to bump local Scottish women off the short list. Jeez. Dang, Black woman don't deserve the spot is what she's trying to say. These allegations taken together tarnish Harvey's public reputation such that none of the alleged defamatory statements could bring her reputation any lower. As such, Harvey is a libel-proof plaintiff and her claims fail. So you've done all of these things. You done harassed this whole law firm to the point they had to put security up. You've done this, you've done that. You showing up to doctor surgeries and yelling at them? Like, absolutely not. You cannot do these kind of things and then expect for someone saying that you stalked a comedian at a local bar, all of a sudden, whoa, that really harmed your reputation. What about when you said that Black lady was basically, what do you call it? A diversity person put in to help get rid of the white women. Like, come on now, lady. You stalking a little man. And I know some of the things that are portrayed in the actual series are a little bit worse than stalking a little man, but you guys get my flow, right? She's already harassed so many people. She's already kind of known for stalking, allegedly. So is it really so bad to think that she did these things? Is essentially where Netflix is going with this. So Harvey failed to allege that Netflix acted with actual malice. The First Amendment prohibits public figures from asserting defamation claims unless they can demonstrate that the defendant made allegedly defamatory statements with actual malice. Harvey, okay, so I did read it right. She injected herself into a public controversy concerning her stalking and harassment of various individuals and thereby became a limited purpose public figure on issues related to stalking, harassment, and assault. Okay, I completely missed that sentence when I was reviewing this. Despite this, Harvey does not really attempt to allege actual malice. The closest she comes to alleging that actual malice failed to the closest she comes is alleging that Netflix failed to conduct due diligence. But the Supreme Court has made clear that failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish a reckless disregard. And remember, that was her big thing that I said, maybe she can win on negligence, right? She didn't do her due diligence. Netflix didn't do their due diligence. They didn't follow up or whatever it may be. But also, there's reasons why she shouldn't win on that theory. And failure to investigate, they're literally the streaming service. They're not the one writing the content, right? So can we make them liable? It's similar like when people leave comments on, your YouTube channel and say, hey, Brianna, you suck, or Boss Attorney Bree, you suck. I can't then go sue Netflix and say, hey, I can't go and sue YouTube and say, hey, YouTube, you told me that I suck. I'm going to sue you because I don't suck, actually. Not defamation, but you get what I'm saying. You're being mean to me. You're harassing me, YouTube, by saying your channel sucks, Boss Attorney Bree. Why don't you freaking get off the live stream? If someone comments that, I cannot sue YouTube, okay? Probably can't sue anybody. That person's just mean. I should probably just block them. But you guys get where I'm going, right? It's a platform. You can't sue them for things. I mean, they approve it, but yeah. Their expressions. Okay. Anyways, let's jump back into it. I'm trying to think if I can get through this before jumping into chats, because chats they're not building up too bad. So y'all let me know what y'all think is going on and about this case. Actually, I'm sorry, y'all. I'm all over the place today. I forgot to set a like goal for the stream. We're already at 33rd. We're already at 33 likes. So shout out to the BriHive. Let's go ahead and set the like goal to 60 likes because we got a little bit more of the live stream to go. So we'll set the like goal at 60 likes. I'm sorry that I forgot to do that in the beginning of the live stream. That kind of sucks. Bree, Boss Attorney Bree, you suck. You didn't set the like goal. Cannot sue YouTube, okay? Cannot sue Boss Attorney Bree for saying that I suck on my own channel. Like, I can't. I probably could, but that would be not that smart. Anyways, let's go on. Can y'all tell I'm tired? Can you tell I'm tired? Okay. Harvey's remaining claims must be dismissed as they are duplicative. It is well established that when a complaint alleges defamation as well as other causes of action based on the same allegations, the additional claims should be dismissed as surplusage. Every allegation in Harvey's complaint is connected to and made in support of her defamation claims. Series of purported, these are the things Harvey's summary of the series purported identification of Harvey and her purported injury in connection with being supposedly identified as Martha, a section labeled defamation describing the purportedly defamatory statements, allegations that Netflix failed to diligence the purported lies, to do due diligence. They're missing a couple of words, right? Allegations that Netflix failed to diligence the purported lies. I mean, I get maybe is diligence a verb? I don't think you can use diligence as a verb, but whatever. For purported lies before disturbing, discussing the popularity of the series. As such, Harvey's claims of IIED, negligence, gross negligence, common law right of publicity, and statutory right of publicity must be dismissed as surplusage because they do not rely on any additional allegations beyond those already forming the basis of Harvey's defamation claim. Let's see here. Next part. Okay. Harvey's IIED claim, intentional infliction of emotional distress. The state Sorry, y'all. I cannot read right now. To state a claim for IAED, Harvey had to allege that Netflix engaged in outrageous conduct that was the proximate cause of her purported emotional distress. Harvey wholly failed to do so. She does not identify what specific conduct was specifically outrageous, instead referring vaguely to defendant's conduct herein. Outrageous conduct is conduct so extreme to exceed all bounds of the of that usually tolerated in a civilized society. Let's see. Some examples that they give is interviewing young children with no adult present concerning the unaliving of two children and their mother. Another example is 48-year-old medical doctor having sexual relationships with minors while providing her alcohol and controlled substances. Yes, that is very outrageous. Very outrageous. That is a step above not checking the facts of someone's story as it relates to the other person's opinion. Yeah, that's really outrageous. Okay. No conduct that Harvey alleges comes close to outrageous. The series does not even mention Harvey, and even if the Martha character was not fictitious, a reasonable viewer would not have associated Martha with Harvey. The possibility that an internet sleuth might have connected the series' use of the phrase hang your curtains with a single tweet from Harvey 10 years ago does not equate to conduct so extreme as to exceed all bounds of that usually tolerated in civilized society. The disclaimer in each episode only reinforces the reasonableness of Netflix's conduct in distributing the series. Even if Netflix intended to out Harvey as Gad's stalker, and it did not, accusing a person of stalking and stating that one is afraid of her is extreme and outrageous conduct, especially if you already being accused of stalking, right? Nor is any purported failure to investigate. Let's see. A case cites refusal to properly investigate is not outrageous, even if intentional and willful. Another case says failing to investigate does not itself constitute extreme and outrageous conduct. Harvey also fails to plausibly allege that Netflix supposedly outrageous conduct was the actual and proximate cause of her emotional distress. She alleges that after being identified in quotation marks, she has been tormented and suffered emotional distress. And she claims that she is fearful of leaving her home or checking the news, and they give a good read right here. But Harvey had no problem leaving home or becoming the news on May 9, 2024, when she sat down with Piers Morgan for a nearly hour-long interview. These judicially noticeable facts make clear that Harvey, not Netflix, was the actual and proximate cause of any purported emotional distress she suffered as a result of being identified as Martha. Essentially, had she never confirmed that she was Martha, she would not have received the hate messages that she received. Just be quiet, Martha. Don't confirm nor deny. Move on. Ignore. I'm not Martha. Go away. If you keep saying I'm Martha, I'm going to sue you. People will go away. Okay? They will go away. Okay, Harvey's negligence and gross negligence claim also fails. To state a claim for negligence or gross negligence, Harvey needed to allege the existence of a legal duty to use due care, a breach of that duty, and the breach of approximate cause of plaintiff injury. It goes on to cite a case that said because gross negligence is simply a degree of negligence, the elements of the claim of gross negligence are the same as regular negligence. First, Harvey asserts that Netflix owes her a duty of care to accurately represent her in baby Reindeer. To confirm the details of allegations made about her in the baby Reindeer is true, and to sufficiently ensure Harvey could not be identified based on information in baby Reindeer. These allegations all relate to how she purportedly these allegations all relate to how she was purportedly depicted in the series. They are defamation allegations. They cannot also be a basis of Harvey's negligence claims. It is well established that a streamer like Netflix owes no duty to confirm or ensure the accuracy of works it streams, separate from the duty not to defame, which it's assumed in Harvey's defamation allegations. Let's see here. They're citing a case that says, oh no. Yep, they're citing a case that says plaintiff has cited no authority from California establishing that a publisher of information owes a duty of care to the subject of its statements where the publisher is also sued, as here for defamation or product disparagement, nor has the court found any authority supporting this proposition. So as far as the court knows from 2007, that might be a while ago, there's nothing saying that the streamer is responsible for basically negligence against a person. But even assuming that Harvey could assert a separate negligence claim based on allegations regarding her purported depiction in the series, there is still no duty as a matter of law. California courts have declined to find a duty under the Rowland factors, see Rowland versus Christian, for claims implicating expression, not acceptable to impose duty upon artists, to restrict creativity to avoid dissemination of artistic speech. The series is indisputably an expressive work, and Netflix thus does not owe Harvey a duty with respect to its dissemination. Absent any such legal duty, Harvey's negligence and gross negligence claim fails. And I kind of wonder if this is what they're going to what do you call it? I guess it's not negligence necessarily, but the case with, what's that guy's name? I can't even remember his name now. From the Nickelodeon case that we covered. I wonder if they're going to use arguments like this. Of course, anti-slap and the fact that this is an expressive work. I mean, because that falls under anti-slap. It's under the First Amendment. So freedom of speech and creative works and the way to basically place your characters and describe the script and everything. We covered that in the Lizzo case that has been put on pause because they're appealing. But similar things there. Dan Schneider. Thank you, Kimmy. Kimmy always knows. Kimmy knows best, okay? It's like, how do you pull it? I was like, I had it and it just slipped my mind. Dan Schneider, that case is the one I was talking about. So let's go on. Second, even if Netflix somehow owed Harvey a duty of care, it did not. Harvey still fails to adequately allege Netflix breached that duty. As discussed, a reasonable viewer would not associate Martha with Harvey, and the possibility that an internet sleuth might have connected the series' use of the phrase hang your curtains with a single decade-old tweet does not indicate that Netflix therefore breached any purported duties Harvey wishes to ascribe. The disclaimer in each episode only reinforces the care that Netflix took to ensure. Did I scroll back up? This is like the same exact thing. To ensure fictionalized characters were not associated with real individuals. Finally, Harvey fails to plausibly allege that any purported breach of duty was the proximate cause of her purported injury. As her IIED claims, she alleges that since being identified as the real Martha, she has experienced panic, fear, anxiety, sleeplessness, despair, and is reluctant to go outside, watch the news, and has become inhumanely isolated. Yet again, Harvey, not Netflix, was the proximate cause of any injury she suffered, given that she identified herself as the Martha character when she really doesn't know if it was actually based on her. Because like I said, maybe part of it was based on her, but maybe he pulled from different experiences and just put it all into the same character in his expressive work. Okay. Yes. Okay. Harvey's right to publicity claims also fail. I don't know if I'm getting sick, y'all. Okay, I'm almost through with my reading, my constant reading. Okay. As a threshold, Harvey cannot maintain a right to publicity claim because the series is an expressive work subject to First Amendment protection. Under the First Amendment, a cause of action for appropriation of another's name and likeness may not be maintained against expressive work, whether factual or fictional. This protection applies whether the publication involved was factual or biographical or fictional, as privacy rights have not been held to outweigh the value of free expression. After all, entertainment is entitled to the same constitutional protection as the exposition of ideas. Expressive works encompass a wide variety of media sold for profit, including books, plays, movies, and video games. Let's see here. It is indisputable that the series is an expressive work, and the First Amendment prevents Harvey from maintaining a right of publicity cause of action. Even if the series was not an expressive work, which it is, Harvey's claims would still fail. To state a right of publicity claim, Harvey must also allege knowing use by the defendant, as well as the direct connection between the alleged use and the commercial purpose. Harvey cannot plausibly allege that Netflix used Harvey's identity. Harvey does not contend that the series uses any historical footage of her, that it uses her name, or that it depicts real events from her life. Indeed, the only allegedly identifying characteristics are that she is a female Scottish lawyer living in London who visited a pub that Gad worked at in 2014. These details are far too general to establish the use of her likeness. And it also doesn't even show a freaking picture of her. Plaintiff not only is citing a case saying plaintiff not entitled to recover under a commercial appropriation of name or likeness theory merely because respondents use a name that sounds like plaintiff's name and because defendants were creating a fictionalized artistic work, their endeavor is constitutionally protected. Moreover, she fails to adequately allege that the appropriation of her name was somehow to Netflix's advantage, commercially or otherwise. Instead, she only includes conclusory assertion to that effect. Even then, she fails to allege that there is any commercial value actually associated with her name. You're not that famous, Martha. That's what they're saying. You're not that famous. What value would we get by using your name? And not only that, we didn't even use your name or your likeness or your picture or anything. It's not like we're saying, hey, buy these Beyonce chips and put in a picture of Beyonce on the chips, because people want to eat the chips that Beyonce eats, I guess. I don't know. Maybe they do. Maybe they don't. I don't know. But that would be a commercially, like, nobody wants to buy Martha chips, okay? Nobody wants to buy Fiona chips. No one wants to do that. And let me say Fiona Harvey, because we do have a Fiona Davies in here, and maybe people want Fiona Davies chips, but not Fiona Harvey chips, okay? Harvey fails to adequately allege punitive damages. We're almost done. Punitive damages are only available where it is proven by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice. At the pleading stage, district courts in California regularly dismiss punitive damages claims for lack of specificity. Harvey seeks punitive damages with respect to her defamation, IIED, gross negligence, and right of publicity claims. As to defamation, IIED, and gross negligence, Harvey alleges only that punitive damages are warranted based on Netflix outrageous conduct. That is not the standard. Even if it were, Netflix conduct was not outrageous, and Harvey does not otherwise plead any facts that could plausibly give rise to a finding of fraud, oppression, or malice. As to the right of publicity claim, Harvey does not allege any basis whatsoever for punitive damages. She just says, give me punitive damages right now. Okay. Finally, Harvey catch-all regarding punitive damages is impermissibly conclusory. Let's see. The court should dismiss Harvey's punitive damages demand. As such, they are requesting that the court just dismiss the whole case because Fiona Harvey failed to state a claim. I think that Netflix came up with some pretty good arguments. Do I know if they're all right? No, I don't know if they're all right because I don't practice that kind of law. But in general, I think they're pretty good arguments as to why Fiona's case needs to go away. I think anti-SLAPP applies. It is a freaking series, right? It's dramatized. It's saying that it's not a true story, although they might have messed up in the beginning saying this is a true story. It's a true story to him, a true story that he put together, maybe. I don't know. So let's go ahead and jump into the chat and see what y'all have to say about the case. All right. Let's see where we are. We got Stargazer Kawaii. Hello. I'm not sorry. Let me get into my comment reading mode. Stargazer Kawaii says, I'm not sure 100% that the internet would have left her alone if she said no. That is also true. That is, they might not have left her alone, but had they not left her alone after she said, no, I'm not Martha, or ignored them, then I think she might have a better claim versus coming out and saying, oh yeah, I'm her. you know what I mean? Not necessarily saying they would have left her alone, but you're right. Maybe they would not have left her alone. But her coming out and saying it kind of defeats her claim and saying, okay, well, you caused it because you admitted that you were her, right? And then you did an interview about it. Phoenix Waller says, so she got a history of stalking. That's what they're saying. That is what they're saying. Phoenix Waller says, friggin' trains of thoughts going off the rails. Yeah, I'm losing it. It's a moral of the story. Don't out yourself as the poop person if you don't want the internet to know you're a poop person. Exactly. Kind of like the Streisand effect of maybe no one was really paying attention to her. Maybe somebody said something and then someone might have seen it and they spread it, and maybe it goes down and it dies down in a couple of days. Because a lot of like the controversial stuff dies down in a couple of days. It's not something that will probably continue for too long, right? Especially if you're not the one acknowledging that it's you. Who knows? Stargazer Kawaii says, how many other similarities are there besides the tweet? I think that in her appearance, she's saying that she was depicted like her, like heavy set, dark hair, colorful shirt, apparently. And that apparently she went to the bar that Gad worked at, and that she thinks that the interaction is based off of. Chris Mullen says, should they not have said inspired by a true story in their show rather than based on a true story? The first one tells me inspired but fictional, and the last one tells me based on with some truth. I don't think it really makes a difference. In my opinion, maybe there is some type of definition that does change it. For me, it doesn't really make a difference for me. And welcome back to the live stream. Kimmy says that Chris Mullen, they didn't even say it was based on a true story. In the part Harvey's complaining about, they just said this is a true story. Yes, that too. Kimmy is right. In the beginning, when it first pops up, it says this is a true story. But Netflix is trying to say, but then underneath, they're saying, as a disclaimer, this is fictional and has been changed and it's not to represent any person in real life, which I mean, it's kind of like, this is not about Obama, but it's about Obama. It's kind of one of those situations to say, yeah, this is a true story, but also it's fake. It's essentially what they're saying. Just Stacy says their documentaries are not always non-biased either. Exactly, they're not. But documentaries, nothing that is put out is non-biased. Whoever is creating it, they have some part of bias. They have some kind of bias. They're wanting to tell one side more than the other, even if they have no cat in the race, dog in the race. What is it? Horse in the race? Whatever the saying is. Kimmy Lockett says, just Stacy, when I watch a Netflix doc, I follow up with Google to see what was left out or twisted. Some are worse than others, but I can't remember any that didn't have some level of bias. And I honestly think that's anything you put out. Me on the internet, right? I'm going to have some level of bias because I'm a lawyer, right? So I'm going to lean more towards, okay, well, that makes sense under the law or whatever it may be, or maybe I like this person more because it's a lady versus a man. I try not to do that, but you know what I'm saying? Everyone has some level of bias, even if you're not trying to have a level of bias. You just got to catch it, right? Just Stacy says, right, my sister watches them and believe they are true documentaries. It drives me crazy. Again, and certain people, you watch it because you like how they tell the story, and maybe some people like Netflix documentaries because you like, and we've seen, like, my brain is all over the place, y'all. We've seen situations where multiple people tell the story and different details are seen as important. They put different details in between, like, Wives with Knives and Sisters That Kill and all those shows. I don't know why I did all murder ones. But they all tell stories different and they all use different information, but probably the main general information. Y'all get what I'm saying, right? Everyone tells a story differently. Stargazer Kawaii says, I would think that viewers would think the character was made to parallel the real person when it's based on a true story, like they said. That's why people looked for her. Yeah, I would agree with that. But I also think I think Chris Mullen was the one that put the difference between the inspiration and the based on. I think it would kind of give me the same feel. This is based on someone, right? Kimmy Locker says, Netflix really said everyone already thinks you suck, so everyone already thinks you suck, so we can say what we want to. Exactly. Exactly. Jermaine Down, thank you so much for the super chat. Definitely appreciate it. Says, I believe if Martha was representative of Fiona, he was too kind to her. Fiona's real life messages are reprehensible. Yeah, so like, yes, he's saying that she stalked him in the show, right? But then you turn around and she has a whole law firm going under lockdown essentially because of the stuff that she's saying to them. And so she basically wants people to believe, like, I'm not that bad as it was portrayed in the documentary, but I am bad enough to where I'm going to spread rumors about your law firm, make your staff scared for me to come in there, cuss people out while you're doing surgeries, and saying all of this other stuff. I'm that bad, but I'm not that bad. It doesn't make any sense. And that's why they're arguing that she is someone that you cannot commit libel against because she's already a bad, bad girl. Thank you very much for the super chat again. We got Kimmy Locker saying Jermaine down, right? They left out some serious, heinous messages. And I don't even know everything that she said before. Stargazer Kawhi says, but was her reputation damaged on a worldwide scale? That I wouldn't know. Like I said, it seems like she would be more relevant in Scotland, not necessarily Netflix. And so I think you do have a point going there. Maybe she sucked in Scotland, but maybe not in America yet. So she's saying you defamed her in America this time. Destin to be says, it is tough one to call Kawaii. Yeah, I agree. Jermaine down, thank you again for the super chat. Definitely appreciate it. Says, wish me luck tomorrow, everyone. I have an interview with a local big law firm as an IT systems administrator. Well, good luck. Yes, we are going to give you some not that one. Gosh, Brianna. Fairy dust. We're giving you fairy dust and wishing you luck. Let's do it again to get rid of that little drum. One more time. Wishing you the best of luck in getting the job as the IT system administrator. It sounds so fancy. Thank you again for the super chat. Stargazer Kawaii says her actions are keeping the media on her. So it's like, what percent is her and what percent is Netflix? Yeah. Netflix, like, you did this to yourself. If you would have just sat down and be quiet, it would have all got brushed under the rug. But you didn't want to do that. You did not want to do it. Tiny says, I actually feel like it's more so her Kawaii. I hadn't really heard anything about it. She keeps the news cycle going. She is pushing it. And then even follow the lawsuit. I feel like it's drawing attention to it, right? Kimmy Locker says, I wonder if and how much she gets paid for doing interviews. Good question. Did she make the money she would have lost by the defamation? Quotation mark. Stargazer Kawaii says, internet sleuths can be obsessive. So if she said no, I don't know if they would have stopped considering other similarities like her being a lawyer. Yeah, I don't know. And it's very possible that they would have continued to bother her. I think where she messed up is admitting so early on that it was her to make it so that now more people found her. Because someone might have just put it up and people were like, okay, well, you don't know. No one's confirmed that it's her. So we're not listening to you. Or they could have said, oh, yeah, let's keep bothering her until she says it is her. We don't know what would have happened. But since she did go out and claim to be her, it's kind of like, okay, well, you've been claiming it's you from the beginning. How do we know you're not the one claiming it for attention? I don't know. It's hard to tell. Kimmy Locker says to Stargazer Kawaii, internet sleuths are ruthless, which is why I can see Netflix's argument that a reasonable viewer wouldn't have made the connection. That's a good point too. Because I sure as heck wouldn't have done all that. I'm definitely not going to look for people. That's one thing I'm not. Might jump into a rabbit hole on Reddit that says this is the person. I might do that. Me actually going to look for stuff, I can see how Netflix is saying that it's unreasonable for people to do that, right? And it's going to be a very small community because even with the small, and I know I didn't watch the show and I didn't look up stuff for it, but even with the large amount of people that watched it, I still didn't hear of it until the complaint came out, right? Chris Mullen says, why would you out yourself as a stalker featured in Netflix series if no one knew who you were before that? Yeah. But she was a stalker in other life events in real life. Fiona Davies says, it's Donnie's true story. It goes full circle to him typing it at the end. Yeah, exactly. And that's what Netflix is arguing. Chris Mullen says, horse in the race. LOL. Guess it's the cat in the race. What kind of cat races, Brie? Cats don't race. Stargazer Kawaii says, I'm guessing more people saw a true story based on a true story. Yes. So the beginning does say this is a true story. And I think at the end it says based on a true story. Sorry, y'all. Chris Mullen says it's like people who watch The Crown and think that it's all 100% true. Every aspect of it. Oh yeah, exactly. It's similar to that. It's similar to that. Chris Mullen says, "Hey, I am not that bad. I am in fact much worse." Get it right? Yeah, exactly. I'm way worse than that. Don't ever say I'm so amateur that I just sit outside your house. I'm gonna bomb your house. Let me not say that on the internet. Never mind. Never mind, y'all. Okay. Anyways, I was gonna try to read Richard Gadd's declaration, but it's long and I don't have much fuel left in me. I'm already feel like I'm getting sick or something right now. So let's jump into Ashley Benefield. So Kimmy, let me know if you got the documents you think are cool highlighted already. So let's see where we're at. Bossy B, where you got? Where you at? Okay. Thank you. Kimmy is uploading the documents that we need for Ashley Benefield. And so while we do that, I'm just going to remind y'all to hit the like button if y'all haven't. Let me actually go ahead and check where we are with the like goal. We are at 44 likes. Our like goal for the live stream is 60 likes. So if you haven't hit the like button, please do. It does help us out in the algorithm and get more friends to hang out with us and talk mess about lawsuits that are going on. Okay, so we are almost at the like goal, like 16 away. We're waiting on the documents for, what was I about to say? The documents for Ashley Benefield. Did I already swoop? I think I did. Did I? Well, let's do it again because I can't remember. Okay, so Ashley Benefield was accused of unaliving her husband. She was found guilty of manslaughter, but she was supposed to be going for, I believe, second degree, and she was arguing self-defense. Ashley Benefield basically says that the court messed up. They screwed up royally, in Ashley Benefield's opinion, and she thinks that the trial either needs to be dismissed, she needs to be acquitted, she needs to be able to interview the freaking jurors, okay? She has a lot to say to the judge, so we're going to go ahead and dive through a couple of the things that she is alleging. I do think that the jury allegations are particularly interesting to me, so hopefully that's one that we'll be able to go over today. Let's see. We got the motion for the new trial. That's the only one that I have highlighted right now. And can you let me know if there's any other ones? Okay. I'm just going to start with the motion for the new trial. Okay. Yep. That's the one I got already. Thank you for that, Kimmy. Let's go ahead and jump right into it. Where did it go? That is not the document. That was not even the document, Bree. What are you clicking on here? Okay. Let's see. Download this thing, girl. Okay. Finally got it. We are going into the motion for a new trial. And I guess it summarizes everything. So I guess I can kind of cover the prosecuting one is long. Let's see. Let me mark again because I'm all the way off here. Excuse me, y'all. I cannot breathe. Okay. Black Swan, the ballerina that unalived her husband. Okay. We got the state of Florida versus Ashley C. Benefield, the defendant. This is a motion for new trial, request to interview the trial jurors, and the incorporated memorandum at law. They go on to talk about the prosecutional, I'm going to call it prosecutional. It's girl, the prosecutor's misconduct. We're going to go with that. They go over the legal standard. Essentially what they're alleging is that the prosecutor did things that were wrong. First, they start off with false statements about Douglas Benefield filing for sole custody. They go ahead and state that during the closing argument, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated on May 4th Only a few days later, after she files for another injunction, Doug files for sole custody of the child. This statement was entirely false and unsupported by any evidence presented at trial. In fact, the court docket shows that it was actually Benefield who filed a motion on May 4th, not Douglas Benefield. The prosecutor further emphasized the false claims in her PowerPoint presentation displayed to the jury. Now, the only thing that I would say about this is I don't know if they objected to this during the closing arguments because I have not watched the closing arguments yet. I was just saying the stuff about all the prosecutor misconduct was long, Kimmy. That's what I was talking about. Let's see. Sorry. Okay, so then we move on to the next one. She also states that, or her attorney states that this improper argument implied that the state had information not presented at trial, suggesting that Ms. Benefield was going to lose custody of her child, the final motive put forward by the state. Such comments referring to matters outside the record are clearly improper. A prosecutor may not refer to facts not in evidence, as it constitutes a form of unsworn testimony not subject to cross-examination. Given the highly prejudicial nature of the false claim about Mr. Benefield seeking sole custody, there is a reasonable probability it affected the outcome of the trial. Moreover, the improper comments deprived Ms. Benefield of a fair and impartial trial, materially contributing to the conviction, and were so harmful and fundamentally tainted as to require a new trial. So the prosecutor screwed up, so give us a new trial. Ms. O'Donnell's statement exceeded all acceptable bounds of advocacy and deprived Ms. Benefield of a fair and impartial trial. The new trial is warranted on this ground alone. Again, then they go, so first they say she brought up facts not in evidence by saying that Doug was trying to get sole custody, hence why Ashley had to unalive him, because if she didn't, he may have gotten full custody because of her behavior. The next thing they accuse the prosecutor of doing is improper attacks on and belittling of Ms. Benefield's character and identity. The prosecutors repeatedly and improperly attacked Ms. Benefield's character, calling her a manipulator at least 14 times during closing arguments, and claimed she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. Such vituperatively, there's no Lee on there. Vituperative, whatever, characterizations of defendants are improper and prejudicial. For example, Suzanne said, the defendant trying to say he was in a fighting stance, he lunged at me. That is just her once again trying to manipulate the system. She's trying to manipulate you. She then goes on to say, first of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that you were talking while this had a mutual injunction, they were, I'm sure. Miss Benefield was lying to him. So basically accusing the husband and the wife of talking while the injunction was in place. But I don't think there's any evidence of that. She's just wanting the jury to assume that was happening. She also says, I'm sure Miss Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it. So again, she's saying she's using him, right? This letter we've heard about that Miss Benefield testified to about all the things. It's another effort of manipulation. They also say, I keep saying manipulation, and the reason is because the defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the expert. She kind of did, right? That's what she said. I don't even think she told them the same story. She told you based on what they said. They also go on to say, he also spoke to Miss Benefield. Mr. Hagg also spoke to Miss Benefield, so clearly got one side of the story or a made up story. She also says she's manipulating Dr. Broder, right? She's manipulating Doug for sure. It's manipulating, and that's what she does. That's what she's done. The evidence has shown to you. She also says, I would submit to you that Ashley Benefield is very smart. She's been working in the system or trying for years. Again, she says, just because she says she didn't mean it, it's true. And that's because As I said, she tried to manipulate the system in South Carolina. Again, she says mutual. She tried to manipulate the system in Florida. Then she also says she tried to manipulate experts. I think in some cases she did, and she's trying to manipulate you. He then goes on to say, the attorney is saying, these inflammatory attacks on Ms. Benefield's character serve no purpose but to inflame the minds of the jurors against her. Such arguments are clearly prohibited. He goes on to reference the prosecutor. The prosecutors also ridiculed Ms. Benefield's testimony, with Ms. Frill stating, you can decide what you think about her testimony. She's a witness like any other, but I would submit to you that was all manipulation. There was no tears. That sucks. And they say, if you have common sense, if you cry and have to take breaks and you're racking, then you're going to have swollen face. Your eyes are going to be all puffy with snot. She also said she'd been crying for 15 minutes, didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. Okay. Sorry, y'all. I might not be able to get through this because I can't even breathe all the way. Vituperative. That's what Kimmy says, how you say it. Such vituperative. I mean, I guess that's easier than I was trying to pronounce it. Characterizations of the defendants are improper. The prosecutor cannot engage in vituperative or pejorative characterizations of the defendant or needless sarcasm revealing that the prosecutor has abandoned any semblance of professionalism. In the words of one viewer, the prosecutors sound like a couple of high school bullies. So they are looking at YouTube for their commentary in this. Still not enough. The prosecutors went even further to claim that Ms. Benefield was lying with no evidentiary support. They said she told defense experts a made-up story, again, without any basis in the evidence. Such attacks on the defendant's credibility are improper. Where the case against a defendant is weak or tenuous, a prosecutor's contention that the defendant is a liar could rarely, if ever, be construed as harmless error. So they accused her of being a liar, yeah. And they didn't impeach her. That's the thing. If they would have impeached her or they would have, alluded to her credibility, then maybe they can call her a liar. But they didn't do that in this case. Improper speculation about out-of-court conversation. Prosecutor Fields engaged in improper speculation about conversations between Ms. Benefield and Douglas Benefield, stating, first of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were. I'm sure Ms. Benefield was lying to him. There is no evidence presented at trial that Ms. Benefield and Mr. Benefield were communicating while the mutual injunction was in effect. The prosecutors claim that they were. I'm sure talking implies that the state had information not presented at trial. Such arguments referencing matters outside of court is improper. I don't necessarily think that the statement implies that they had information outside of trial. I think what it's referring to me, and y'all can correct me if I'm wrong, is wasn't the injunction still in place? Hence why they were going to a hearing regarding the injunction and then also, I believe, the divorce in custody coming up. If I'm mistaken, please let me know. But I would infer that if they were planning on moving to Maryland and there was an injunction in place, which in my understanding, it was still in place. Maybe it wasn't in place anymore. I could be wrong. If you guys are talking about moving and he's helping you pack, then you kind of have to be talking at that point. And I think that's what the inference was, but I could be wrong about all those facts. So don't cite me on that. There was also false claims by the defense expert's testimony. And we got a lot of this in, what's her name? What's the other girl's name? In the Clayton Eckert, Laura, whatever her name is, basically saying that there was facts in the order that wasn't in the actual testimony. That's kind of what we're dealing with here. False claims about the defense expert's testimony. The prosecutors made false claims about the testimony of the defense expert, Dr. Emma Liu. Prosecutor Field stated, Dr. Liu is a medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And she did that because she's getting paid to be here. That's why she's here. That's why she's saying those things. That's kind of bad. That's kind of bad. Like, this does not seem like seasoned prosecutors. And I don't even do criminal law. I don't think you can say that. You can't just make those assumptions, those conclusions for the jury. You can't do that. Oh my gosh. Okay. There was no evidence presented that Dr. Liu was being paid to testify or that she testified the way she did because she was being paid. Ironically, at the same time, her testimony and as this being written, Dr. Liu had received no fee whatsoever. The prosecutor never even asked Dr. Liu if she was being paid. Yeah, and they didn't even ask that on the stand. That's bad. This improper argument suggested without any foundation in the record that the defense had suborned perjury from the expert witness. Such comments like highly irregular, impermissible, and prejudicial. I didn't read everything on this because I was trying to skim and get ready for the stream. I think they're going to get a new trial. If everything that they're saying in here is true, I think they're going to get a new trial. Especially on the comments about the doc. You never even asked if they were paid, assuming that this attorney is telling the truth. Yeah. And saying they testified about this. That's why they testified about this. They should have been our witness, but they decided to go be their witness because they're getting paid. Like, that person is immoral and lying on the stand. It's like one thing to accuse the defense because they're trying to defend themselves, but like the actual doctor, that's messed up. Even did that during Gutierrez retrial when their gun expert pointed the gun at the judge. People didn't even do that. Owens, Lord Owens. Thank you, Kimmy. Always got the names for me. Let's see. Moreover, the prosecutor improperly denigrated the defense theory and expert witness. A prosecutor may not ridicule a defendant's theory or of defense. What did they say to ridicule the defense, though? Okay. Again, and then there was also improper appeals to emotion and sympathy. They didn't really cite what about the theory the prosecutor basically ridiculed. The next thing that they claim is improper appeals to emotion and sympathy. The prosecutor made inflammatory arguments clearly designed to arouse the emotion and prejudices of the jury against Miss Benefield. They said, afterwards, she run over the neighbor's house. Not once do you hear her say, get an ambulance. Not once did you ever hear any concern that I just shot another human being. And she was the only person armed in the room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asked for an ambulance. And he dies. She had an agenda. And she got what she wanted because after she killed him, what did she get? Sole custody of the child, which is what the prosecutor was pushing as her entire motive of doing this. And mind you guys, that is not all read in order. I kind of skipped around to what Kimmy highlighted, and it actually flowed very well. And then they go on to say such arguments that serve only to inflame minds of juror. As held in this case, closing arguments must not be used to inflame the minds and passions of the jurors, so their verdict reflects an emotional response to the crime or the defendant rather than the logical analysis of the evidence applicable at law. The next thing they also argued here is that they did improper burden shifting. So if you know, in criminal cases, it is up to the prosecution to prove their case. They have to do their prima facie case and prove their case beyond a reasonable doubt. Then it's the defense's turn to cast doubt into their theory. So state puts on their case. They should be all good to go. No holes in their theory, right? It shouldn't be holes in their theory. Then the defense comes and pokes holes in their theory. But also Ashley is arguing self-defense. So she has to do her prima facie case of I had self-defense. And then it's up to the prosecution to come poke holes in her case. I don't know why I'm doing that with my hands. I don't. I really don't. Just poking the holes in the air. So the prosecutors repeatedly misstated the law on self-defense, telling jurors they needed to evaluate whether Miss Benefield's use of force was reasonable and necessary. For example, so the real questions in this case is their self-defense was their justifiable self-defense, and the self-defense instruction is long. Justifiable use of deadly force would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony, is what they said. Ms. O'Donnell further shifted the burden of proof impermissibly in closing argument when she highlighted and emphasized the incorrect instruction in her PowerPoint presentation, which self-defense is Ashley Benefield was justified in using deadly force, believed that such force was reasonably necessary to prevent imminent death or great bodily harm or forcible felony. During a rebuttal closing argument, Assistant State Attorney Rebecca Phil again argued, then you have to decide, was she justified in using self-defense? And was it reasonable and necessary based on what happened in the house that she shoot and kill him on September 20th? It was not justified. It was not based on self-defense. It was not reasonable and necessary. This argument improperly shifts the burden to Ms. Benefield to prove her actions were justified. The self-defense jury instruction clearly states, and Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, if you find that defendant is guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So she has to present that she had self-defense, and then the prosecution has to prove that she was not justified in using deadly force. Maybe she could have punched him and kicked him in the balls and ran out. Maybe she could have done that, but she was not justified in using deadly force. I was a little bit confused, but they kind of tied it all back together for me. So she still has to prove self-defense, but it's up to the defendants again to poke holes in her theory. She's saying self-defense. Defense has to say, sure, but it wasn't reasonable force. Right? Defendant has a fundamental right to the defendant has a fundamental right to present a defense and to have the jury properly instructed on any legal defense supported by evidence. These rights stand for not if the prosecutor can ridicule a defense so presented, denigrate the accused for her determination in raising the issue, and it may state the law in contradiction of the judge instructions as the prosecutor in this case did. The error committed by the prosecutor in closing argument therefore deprived Ms. Benefield of her fundamental right for a fair trial. With ample evidence to support the defense of justifiable use of force, it cannot be said that the error was harmless beyond a reasonable doubt. Again, they can object during closing argument. I don't know if they did because I haven't watched closing arguments. I would like to know if they objected to these things during closing argument, because if they didn't object to it during closing argument, they could have waived their right to assert it now. And I don't know what rules the judge gave of if they told them to hold all of their objections or do written objections or whatever it may be. But you can object during closing argument. And the court can strike the record. I know once it's out there, you can't really get rid of it. But my question is, and if anyone knows, let me know, did they object during the actual closing argument? Like, yes, the prosecutor sucks by saying this stuff if it's not in evidence, but also did defense attorney do their job by properly objecting to it? Because they could have waived their right in all with that. Okay. False representations of wound path. The uncontroverted testimony was that the wound path of the fatal shot to the defendant's chest was from front to back, left to right. Such was testimony from Dr. Vega, the state's medical examiner. That wound path description was confirmed by Michael Hagg, the defense ballistic expert, as well as Dr. Emma Liu, the defense's physician and just retired Miami-Dade County medical examiner. Despite that, in using the graphic illustration never at any prior time shown to the defense, the state, through Assistant State Attorney Suzanne O'Donnell, represented to the jury that the wound path was side to side. In an event more blatant misrepresentation, Miss O'Donnell used a graphic depiction to demonstrate that the wound path entered the deceased's right side, behind the right arm, transverse to his chest in a straight path, and lodged in his back. This was a flat-out misrepresentation of uncontroverted testimony, which clearly misled the jury. So they're saying side to side as if it just kind of went through, like, he's not even facing her, essentially. But they're saying it kind of went at a diagonal, is what defense is saying. And that's what it looks like all of the experts testified to. This was a flat-out misrepresentation. I already covered that. The cumulative effect, they go on. While no single improper comment may require a new trial on its own, the cumulative effect of the prosecutor's numerous improper and inflammatory remarks deprived Ms. Benefield of fundamental right to a fair trial. I do think it gets turned over. I'm not even done yet. And again, I skimmed this earlier, so I wasn't all the way familiar with everything that was in here. I think it gets overturned. I do. I think not overturned, but I think she at least gets a new trial. I don't know if she gets an acquittal, but I do think that she gets a new trial because it is a lot of inflammatory language. Let me know what y'all think. But I'm seeing here with YX, they didn't object once. They might have waived it. I don't know what the rules were, because sometimes the judge says, okay, don't object during closing. Give me your written objections before we send out the jury or whatever, or, do all your objections at the end or whatever it may be. But I don't know if that was the rules there. Okay. So let me go on here. The prosecutors in this case repeatedly made inflammatory and improper comments attacking Ms. Benefield's character, referencing matters outside the record, making false claims about the evidence, appealing to sympathy, and shifting the burden of proof. Given the nature of the evidence in the case, these inflammatory and improper comments affected outcomes, deprived Ms. Benefield of a fair and impartial trial, materially contributed to the conviction, and were so harmful, so fundamentally tainted as it requires new trial. To establish the harmless error, the state must show beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively that there is no reasonable possibility that the error contributed to the conviction. The state cannot meet that burden. This is similar to Laura Owens saying, well, the court knew that Planned Parenthood was closed on Sundays, and that's the only reason why she found that Clayton wasn't the baby daddy. That's not the only reason why she found that Clayton was the baby daddy. But in this situation, if everything that the defense is saying is true in here and they properly objected, I do think that they can get a new trial based on this, because it's gross misconduct at the least, in my opinion. Okay, that's my opinion, little baby attorney me. I think that it's very inappropriate. Very inappropriate. I'm not too mad about them calling her like manipulative, and because that's what they're painting her as. That's their theory, right? She's manipulative and she wanted custody of the baby. That, I don't think that's bad. But saying that the bullet went in a different way than it actually did, saying that the doctor's only testifying because they're getting paid, like, why are you hating on that girl for getting her coin, even if she wasn't? I mean, even if she was getting her coin, like, you didn't even ask. You can ask. You can literally ask on the stand, are you getting paid to be here? That's like one of the most important questions to ask an expert. It's one of the most important questions to ask an expert. And they're saying you didn't even ask. So yeah, that is inappropriate to then say they're only testifying like this because they are getting paid. You can say, remember, this person is getting paid. Had you asked if they were getting paid, but you didn't ask if they were getting paid. So I think a lot of the things that they're doing here is improper. Question is, did they object? Did they preserve it? Did they move for, I think you move for acquittal at the end of a criminal trial, and they could have used the same thing or requested a new trial based on these same things at the end of the trial, but they would have had to object during the closing arguments, unless there was rules about not objecting during the closing arguments. But honestly, I don't think there was, because I watched the opening arguments and they were objecting during the opening statements. So I don't know. Y'all let me know what y'all think. I might be overthinking it. Finally, in this case, the prosecutor's references to Miss Benefield as being a liar and a manipulator and to matters for which there was absolutely no support in the record. Again, I'm not all the way mad at them for calling her a liar, but I do think that they needed to actually impeach her in order to refer to her as not telling the truth. Or at least refer to some of her contradictions. That would have been better than outright calling her a liar, right? Calling her a liar, a manipulator, and to matters for which there was absolutely no support in the record in a matter of both pejoratively and sarcastically, all of which form the basis of Miss Benefield's motion. Were so invasive and inflammatory. It was questionable whether the jury could put aside the prosecutor's character attacks and decide the case based strictly on the evidence. Let's see. Because the present case chiefly involves the testimony of Miss Benefield, the undeniably crucial issue was the juror's perception of Miss Benefield's credibility. And exactly, if they wanted to impeach her, they should have impeached her. Then they go into the identifiable juror misconduct. Juror 15 failed to disclose. Okay, let me pause right there. I'm gonna go into y'all chats because it looks like there's a lot coming in regarding that. I hope y'all could really understand what I was going through. I know I kept stopping and kind of messing up my words. I know I normally do that, but that one felt a little bit worse than normal. So hopefully y'all was able to work with me through that because it was a struggle for me to get through. Like I said already, I think that if the defense is accurate, and again, I will remind y'all, I did not watch the entire trial. I only watched bits and pieces of it. If the defense is accurately describing what happened in the closing, I do think that they have a basis for a new trial. My question would be, did they properly object to it? They didn't properly object to it. I think the motion is lost. Because in order to like get an appeal or make an objection, you have to object to it. They should have moved for a new trial at that point based on the defendant or the prosecution's representations. But you know, I'm not a criminal attorney, so maybe we should ask Natalie Lawyer Chick. Phoenix Lawler says, I do wonder if letting the jury go. Oh, sorry. Let me get Bossy B in here. Okay, get into the chat, y'all. We are at 47 likes with 30 people watching live. So if you have not hit the like button, please do. Our like goal for the stream is 60 likes. So let's get to our like goal animation, okay? We have Phoenix Waller saying, I do wonder if letting the jury go so late impacted their decision. I think it could have. They could have been ready to go home if they didn't know that they could go home and come back. And that definitely can play a role. Tanya D says they didn't object at the time. I was so mad. Okay, so that's another person saying they didn't object. I have not watched closings yet. So yeah, that's not good. Kimmy Locker says destined to be, it drove me nuts, especially since her attorney was pretty good at objecting during trial, in my opinion. I don't think, from what I saw, I didn't see the whole entire case, so don't get me wrong. I didn't see him objecting a lot from what I did watch of stuff I didn't think should come in. But I don't know. Maybe he used his objection sparingly. Julie 543 says, wait, they didn't object at the time. That's what they're saying. I can't confirm nor deny. Destined to Be said, I know he was sick that day, but OMG, his sinus mess might have kicked in. Yeah. So you better object and sneeze at the same time. Julia 543 says, oh yikes, they didn't want to object during closing, but may have let their ability to appeal that go by not objecting yet. Yikes. Yes. So essentially they're filing a motion for a new trial. The court can deny it, right? Deny you didn't object to it during the trial, or they can deny because they don't think that the defense argument is persuasive. The court has to rule on the objection. So if they say, okay, motion for new trial, but they never objected, the court can deny it. And then they appeal it and they go to the Court of Appeal and they say, well, the court should have gave me a new trial because these things happen. And the appeal court is going to say, did you object to it? And they're going to go, no. And then it's going to be like, oh, well, you waived your right to object. You waived your right to a new trial, or waived your right to a new trial based on those circumstances because you failed to object. You can object during closing arguments. Don't know why they didn't, unless the court said no objections during closing arguments, which they can do in order to not have like a bunch of distraction. But what I do notice in like opening statements and closing statements, the attorneys are a little bit more hesitant to object, but you can strike the record, especially on closing, because assumes facts not in evidence. Assumes facts not in evidence. Misstatement of testimony. You can object throughout it. I know since it was being live streamed, they weren't like blurting out their objections, and it could have been distracting to like object, go to the stand, talk to the judge. Okay, come back. Okay, guys, strike that part about this. Okay, go on. Object. Okay, it's a distraction, sure. So maybe there was some rules to it. Some courts do say no objections during the arguments, but you can bring it up later. I don't know if that's the case here. Julia543 says, I like that footnotes are now YouTube links and timestamps, right? Exactly. Destined to be said, me too. It's crazy, LOL. Destined to be says, attorneys also say I went back and watched what was said on Law and Crime. Yeah, because they want to know the legal opinions on the internet. Kimmy Locker says to Julia543, right? What a strange world we live in, right? It is. It really is, because the juror misconduct is literally them looking at comments on Law and Crime. It's insane. Island says, I think the juror issue is a bigger grounds than this. Yes. I agree. Destined to be says, I agree. The Island, that was crazy. Yes, I agree. And they could still succeed on that. But on these bases, we're not into the juror's part yet. But on the basis above, if they didn't object, I just don't see it happening for them. But if they did object, if they did properly preserve it, I do think they get a new trial. Kimmy Locker says to Island, I think the prosecutor making objectively false statements during closing is a bigger deal, but I don't know if it'll stick since defense didn't object. I don't think prosecutorial misconduct. Yeah, I agree. I do think that the prosecutors did something wrong based on this document, right? But if they didn't preserve their rights, not a good thing. This is something you knew during the trial, right? You knew those facts, or you should have known those facts were not in evidence, because I do trials and we don't always have someone transcribing the trial, and you have to remember what was said. You have to remember what was said and say, that's not in evidence. And sometimes you might be wrong. The court go and look at the notes and they go, no, that's in there. I have that note. That sucks. Right? But imagine being there and you got multiple attorneys on your team being able to pull up transcripts. We saw it live in the Johnny Depp trial, right? Where there was research attorneys pulling up. They're like, no, didn't you say this? And they go, no. It's like, here, look at this transcript from yesterday. What you said, read it out loud. That's big cases like that. That's what you have to do. It's just what you have to do. Kimmy Locker says, should be something that is waived though. Oh, you were saying that the prosecutor misconduct should be something that is waived though, especially since the defense might have had to fact check some things like Doug filing for sole custody if they never heard it before. The thing is, it says that Ashley filed for it. That's fine for that part. That part alone, maybe they didn't know though that, and they went and looked at the transcript, but also they are getting maybe they're not getting it live, but there's cases where you have a stenographer, you're getting that information live, and you should be able to pull that information. And also you should be able to they all have computers. They could have looked up if they heard that. What? And at the end of the testimony, they could have objected, said, Your Honor, I object to prosecutor's statement regarding this. I'm going to ask that to be struck from the record, because they all have computers. They could have looked it up while the testimony was while the closing argument was going on. Now, I feel for you. I definitely understand where you're coming from, but with technology now, it's too much. They should be able to do it during the hearing. Because I have to do it and I don't have. It's just me, okay? It's just me. And so you have to be able to do it. Island says to Kimmy Locker, I think they missed the objection. Yeah, they did. Kimmy Locker says to Island, I think so too, but I don't think missing an objection should waive any right when it comes to prosecutorial conduct. I don't know why I cannot say that word. I know it does, but that just feels so wrong and insane to me. I definitely get where you're coming from, But this is why these cases have teams. So there's one person, getting their questions ready, getting their speeches ready, another person researching, another person pulling this. You saw even in the case, he had that backup attorney that was pulling out documents, doing this, and look, read this one. They had that. So with it the way technology is now, I don't know. I don't think so. I know it feels icky, but it's not. YX says they didn't object once. That's bad on them. You object your butt off in closing. Destin to Be said the prosecutor was off the chain in her closing. I still have not gotten around to watching it. Just because says the closing was okay, but the rebuttal was completely unhinged. Prosecutor's rebuttal, just because says, I wonder if they agreed to not object during closing in an earlier hearing or something. And that's possible. That is possible. And maybe they were allowed to save it for the end. That is a thing. They can do that. Destin to Be said, just because if I recall correctly, the state did object during defense's closing. I could be mistaken though. And I can't confirm or deny because I haven't watched it yet. Chris Mullen says you can be beaten to unalive just as easy as you can be by a weapon. So she may well have considered her life at threat just based on that. Yeah, because she said that he was trained on some type of martial arts. And so literally they can consider your body to be a deadly weapon. That is absolutely true. I don't know if they can do that just based on, I know he did martial arts. I think he would have had to do a little bit more than stand at the doorway and get into a fighting sense. I think he would have had to do a little bit more than that in order to justify that. So, and usually when we're talking about deadly force, we are more looking at like guns and knives and where you're shooting them and where you're stabbing them. We are looking more at that versus, okay, this person has a background in martial arts, but do we know if they're still skilled in it? Do we know if they have weaker muscles? Like, I think that's not what we would normally consider deadly force, right? I think he would have had to do a little bit more for them to consider she needed to use deadly force. To shoot him. Sorry. Lost my train of thought. Okay. Sorry, y'all. I still can't breathe. That's it to be said. Make sure you hit the like button if you haven't already. Yes, of course. Thank you for the reminder. Chris Mullen says, the prosecutors were extremely mean during the trial, mean in a disgusting way. They were kind of mean. They were feisty, but also I do think they were doing their job. They could have been a little bit more relaxed, but I do think they were doing their job. Kimmy Lockett says to Chris Mullen, agreed. I get that the prosecutors have a job, but they didn't need to do it in such a gross way. And they could just be people with attitude. I dealt with this attorney today, and I was like, am I tripping or is this person tripping? Because there is no way you think you're being polite, okay? There's absolutely no way you think you're being polite. And then you want to get mad. Y'all, I had to tell this lady, I'm giving you the energy that you're giving me. Very unprofessional. Well, but in a professional manner. You're giving me that energy, I'm going to give it right back to you. So if you want to start over, we can. Okay? I'm going to give you the same energy. Oh, yes, I apologize. Yes. Like, you just, some people don't know that they're being rude. They gotta know. But I was like, there's no way this girl does not think that she's not being rude to me right now. Because I will cuss you out. You about to pick me because I don't even, like, I'm not even that involved in this case. But the way you're talking is crazy. And I can deal with it with like people that are unrepresented. But another attorney, I'm like, girl, calm down. This is not your mother's case. Like, calm down. But yeah, no, I definitely get that because there are some people that are just like rude off the top. Destin to Be says the attorney acted like Doug was their brother. That's what I'm saying. That's literally what I say. When attorneys are super aggressive for no reason, I be like, bruh, this is not your divorce. Like, calm down a little bit. It's really not that serious. Your client's a liar. I'm like, probably yours is too, but am I going to die on the cross for them? No. Like, why are you going so hard. Like, this is like your case, life or death for your child. Like, calm down. We're talking about bank accounts. It's like you going hard over a bank account? Like y'all got me on a tangent. No, I see what they treat it like it's either like their kid, their life or death situation. And this one is a little bit more serious because it is unaliving. But my case is like, we're talking about a bank account. I don't care if my client is lying. I think your client's lying, but I'm not going to get on my high horse and act like I'm smarter than you because both of our clients are liars. It's not that deep. Chris Mullins says to Kimmy Locker, yes, for sure. And they did come across as sarcastic and rude and bullying. Yeah. And it's a thing. Like, you would think they would be more professional, but it's a thing. Kimmy Locker says, no, that was a 2-part statement. I do not think prosecutor, why can't I say that right? I can say prosecutor, but I can't say that. Prosecutorial, whatever. Misconduct should be something that can be waived. Yeah, no, I'm sorry if I misstated it. Julie 543 says they knew they could come back, but there seemed to be some maybe peer pressure to not be there the following day. Oh, okay. That makes sense for the jury keeping them that long. Chris Mullins says the jury was advised that they could go home and come back the next day, but the jury did not want to do that. So it seems like they compromised on manslaughter in the end in order to finish. They didn't want to have to come back. They were probably tired of going there. Island says they couldn't come back. The 2 jurors were unavailable the next day. So if they didn't reach a verdict, the alternate came in and they had to start over. It was a compromise verdict. That sucks. Kimmy Locker says to Island, I didn't see that, but if that's true, it makes no sense to me. If 2 jurors weren't available the next day, then they could have come the day after that. Yeah, that is also true. Julia 543 says, Island, where did you hear that? Island says, it was stated at the beginning of voir dire. They were told the trial would be done when they came back hung jury, or when they came back hung judge gave them an option, go back and try again, or the alternate next. I heard it in court. Island says, then they came back half an hour later and had a verdict. Island says, except we know you won't cuss her out, Bree. You're too good for that. Yeah, she almost got it. And it was literally my first time ever speaking to that attorney. I was like, I can't be the only one hearing this. Like, and then she started emailing me. And so my paralegal was saying it. She's like, that lady is off her rocker. Like, off your rocker. Julia 543 says, I'm terrible with my tone and expressions, awful with it, and I truly don't mean to be. Yeah, and it happens. Julia 543 says, Bree is like, it's a divorce. Everybody is lying a little bit. Exactly. I'll advocate zealously, but professionally. Exactly. All you have to do is just not agree. You don't have to say it like you was there, like you were not there when that man stole that money. So stop acting like it, okay? Kimmy Locker says, I've been described as an excessively patient and forgiving person, so I'm usually pretty good with my tone, but my face gives it away. Yeah, your face does give things away, Kimmy. I can attest to that. Julia 543 says, we're at 51 likes. We're at 50. What am I, a robot? We're at 51 likes. Liking is free, and I don't think it even needs and I don't think you even need a YouTube account. Yes, of course. If you haven't hit the like button, please do. Our like goal is 60 likes for the live stream. It's showing me 50 on my end. So of course, hit the like button if you haven't already. Now, let me not mess stuff up on my little soundboard that I still barely know how to work. Now we're going to go ahead and jump into the jury misconduct portion of the motion for a new trial, which I have mixed feelings about it. I'll get into it once we get into it. Okay, so here we go. All right, so identifiable jury misconduct as to why they want the jury interviewed. What happened to my little button? What the heck happened to my little button here? Oh, because it's this one, Bree. Get it together, Bree. Okay. Here we go. Identifiable juror misconduct. Juror 15 failed to disclose on her questionnaire material information and further concealed material information during voir dire that would have resulted at minimum in a preemptory challenge by the defense. Okay, because you can get rid of jurors that you don't like based on the questions that they answer. They go on to say, and the Florida Supreme Court has laid a 3-part test to determine whether jurors' non-disclosure of information during voir dire will warrant a new trial. First, the complaining party must establish that the information is relevant and material to the jury service in the case. Second, the juror concealed the information during the questioning. And lastly, the failure to disclose the information was not attributable to the complaining party's lack of diligence. Okay, any juror who conceals a material fact that is relevant to the controversy is guilty of misconduct, and the misconduct is prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. Okay. Once Ms. Benefield has established juror misconduct, she is entitled to a rebuttable presumption of prejudice and thus a new trial. Unless the state can demonstrate that any prejudice was harmless and prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, the alternatively stated that there is no reasonable possibility that the error contributed to the conviction. The concealed information was relevant and material. The information concealed by Juror 15 is highly relevant and material to the case. The 5th District of Appeal has complained that a juror's non-disclosure of information during voir dire is considered material if it is so substantial that the facts were known. The defense likely would preemptorily exclude the juror from the jury. Juror 15 failed to disclose and or otherwise concealed the fact that she was a victim of domestic battery on February 20, 2016, when her live-in boyfriend, blank, intentionally slapped her in the face with an open hand 5 times. Now, I'm going to stop right there. This is why I'm a little conflicted. Because if she was a victim of domestic violence, wouldn't she be more likely to be in favor of Ashley Benefield? Okay. I think that is different. I think that's different. Okay. I don't know. I would say if they were a victim of DV, I would not want them. I would want, if I was the defense, I would want a victim of DV on my side because they can understand like how scared the battered wife, they can understand the battered wife syndrome. Like if he was continuously doing that to me, I would have shot him too. Yeah, I think she was justified. I'm a little conflicted on that. Let me know what y'all think in the chat. Okay, thank you, Kimmy. I got your chat in the back. Okay, let's go in. Next, second part, her son was charged with felony battery against his pregnant girlfriend on August 31st, 2014, and Juror 15 was the bond depositor in the case. So she let her son off. Okay, that one goes a little bit more towards the defense. But I forgot, I think the question was, have you ever been a victim of a crime? And have you ever perpetrated a crime? I think those were the questions, but maybe they're going to bring it up again. I know in the motion to interview the jurors, they gave like what the question was, but I don't see it here yet. And 3, she was the respondent in multiple petitions it was her. She was the respondent in multiple petitions of injunction for protection against domestic violence filed by her ex-husband, seeking protection for himself and their minor child, blank, on the ground similar to those put forth by Ms. Benefield against the deceased Douglas Benefield specifically. Now, that might go a little bit in her favor, but I will say there are several cases when you're going through a divorce where people, the mom and the dad, are constantly filing restraining orders against each other. Doesn't necessarily mean that the allegations are true, and doesn't necessarily mean that she felt like she perpetrated a crime. So I think some of the questions, if I remember the questions correctly, are subjective. I don't think that necessarily, again, because she filed her petition first, right? And then her husband filed 2 against her, which could have easily just been retaliatory. I know I have the injunctions, but just based on it, I don't know if that would have excluded her from the pool of the jurors, especially because she was on both sides of the situation. And she might have thought, I didn't do anything to him. He was just retaliating against me trying to take my kid. I don't know. Let's go on. Okay. Juror 15 was a respondent in a petition for injunction of a protection of DV filed on September 2nd, 2023. And 2003. This was 20 years ago. Maybe she forgot about it. There's those kind of things. By her ex-husband seeking protection for himself and the minor child in the 12th District Court. The petition attached as Exhibit H they have an exhibit list, threatening. She was accused of threatening, and again, this is alleged. This is someone filing saying she did this to me, she did this to me, she did this to me. That doesn't mean that she actually did the things. But anyways, let's go on. Threatening and violent behavior by Juror 15, including cussing, slamming doors, and throwing objects. A suicide attempt by Juror 15 on July 18, 2003, again, 20 years ago, resulting in hospitalization. Constant harassment and threats of Mr. Blank and his wife. Fear that Juror 15 might harm their son in a future suicide attempt. Request for supervised visitation into a Juror 15 demonstrated mental and financial stability. Juror 15 was also a respondent in another petition for injunction for protection against DV filed on April 23rd of 2004. Important to recognize that this was 1 year after. Not even a whole year after, honestly. It's like 9 months later. So what that indicates to me, if this is filed only 9 months later, what it indicates to me is either it wasn't granted or it was granted for a very short time. If it wasn't granted, again, these are just allegations of someone saying this person did these things to me. Let me keep my kid. She's a bad person. That does not necessarily mean she did it. And again, and I could be biased, like we talked about bias earlier. Divorces, custody, messy. People are willing to lie. You would think that people are not willing to lie. They are. So I don't know if this necessarily goes against her as strong as some might think. Okay. So there was another one saying that she physical abuse of the minor child by Juror 15, including picking up the child by the arms and slamming him against a wall. The child expressing fear of returning to Juror 15's home. And a child abuse report filed with the Brighton Police Department. Again, it's him filing the police report, but let's go on. Threats by Juror 15's boyfriend to unalive Mr. Walcott. Why did y'all black out his name up above, but then leave it here now? Whatever. On an ongoing Child Protection Service investigation. It's still ongoing from 2004. And I can tell you right now, this is a divorce case. This is a divorce case. It might be domestic relations because there's 2 different case numbers. Might be domestic relations. But either way it goes. Why is it still ongoing? Oh, because it's alleging that there's an ongoing protective services case, which anyone could have filed, including the person filing the petition for a restraining order. The child showing signs of becoming violent. These undisclosed facts are strikingly similar to the prosecution's theory against Ms. Benefield and would have raised serious concerns about Juror 15's ability to be impartial. The DV allegations against Juror 15, including claims of threatening behavior, violence against a child, and concerns about mental stability, mirror key elements of the state's case in instance. And again, I think that is relevant, right? But also, was the petition granted? Because if you were able to pull all that information, you were also able to prove whether the petition was granted or not. Because the husband could have been lying. So give me a little bit more information about whether it was granted or not. The focus should be on what the appellant's counsel would have done during voir dire had the litigation history of the jurors been disclosed, rather than on whether the court believes the juror were actually biased. Yeah, that makes sense. Given the parallels between Juror 15's concealed history and the facts of the case, this information implies a bias or sympathy for the other side, which in all likelihood would have resulted in the use of a preemptory challenge. The defense would have undoubtedly exercised a preemptory challenge to remove Juror 15 had the information been disclosed. I don't know about that. Again, I'm not in criminal law. It is very similar. It is very similar to the case, Ashley Benefield's case. But I don't know if they would have necessarily preempted her. They're saying that, of course, they're going to say they would have preempted her. But in the moment, also knowing that she was the first victim of the DV. And then, like I said, it looks like they were not granted, and maybe they were, but he's not saying that they were granted. And if it was granted, I think that would have been way more relevant than someone filed a petition, someone filed a CPS report against her, someone filed this, because that doesn't necessarily mean that it happened. There's no proof of it, right? So interesting theory. I'm not all the way on board with that one. If they would have said she was that it was granted against her, I would have been a little bit more on their side. And it does sound really similar to the case. So I see where they're coming from. The juror concealed the information during questioning. Juror 15 concealed the information both on her jury questionnaire and during voir dire. The Florida Supreme Court has held that a juror's non-disclosure need not be intentional to constitute concealment. Whether intentional or not, Juror 15's omission prevented counsel from making an informed judgment, which would in all likelihood have resulted in a preemptory challenge. I wonder why they didn't look this stuff up earlier. The defense exercised due diligence in questioning the potential jurors, and so there it is. Excuse me. Unidentifiable juror misconduct. Lastly, although not yet traceable to an identifiable juror, upon information and belief, and as yet unknown, juror brought a cell phone into the jury room and used it during deliberations, constituting an objective act that compromised the integrity of the fact-finding process and prejudiced Ms. Benefield's substantive right requiring a new trial. I definitely agree with this one. I have no pushback on this one, okay? The fact, during deliberation, a juror brought a cell phone into the jury room and used it while discussing the case with other jurors. The act was in direct violation of the court's instructions and Florida law prohibiting unauthorized material in the jury room. The jury deliberations, a YouTube user, that hoodie guy, posted comments on the Law and Crime Network YouTube live stream of the verdict watch. I'm not laughing. I'm laughing because it's like, why was y'all watching the verdict watch on Law and Crime to even find this information? Or, I mean, I guess someone was on Law and Crime and then reported it to the defense, I guess. I don't know, because there were people on her side. These comments do you really read all the comments? I know on my channel there's not as many comments going up, so you're able to kind of read everything that everyone's saying. But on Law and Crime, there's a bunch of people commenting like nonstop. That's insane to me. Okay, these comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instruction, the sanctity of the jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. The comments posted on July 30, 2024, revealed at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached. That hoodie guy posted a comment stating verdict incoming. At 10:25 p.m., that hoodie guy posted a comment saying, per sources, 5-1 guilty with a man stuck on not guilty or manslaughter. You want to tell me nobody noticed her texting, the alleged juror texting? 10:27 p.m. saying that hoodie guy posted a comment saying, my sister snuck a flip phone in. You know how hard it is to text on a flip phone? No one noticed her texting? Like, no one? Is a bailiff not in the room with them? That's crazy. 10:28, he says, I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. And then sorry, I was thinking about what the other one. Sorry. 10:28 says, my sister snuck a flip phone in. She texts me 5-1 guilty, may compromise on manslaughter. Oh gosh, that's horrible. At 10:30 p.m., a mere 2 minutes after that hoodie guy posted that the jury may compromise on manslaughter, the jury returned a compromise verdict on manslaughter. Why would you even be texting that? The timing and specificity of the comments, followed by corresponding jury action, strongly suggest that the hoodie guy information originated from within the jury room. Was there only jurors in the jury room? I'm sorry, y'all. I'm casting doubt. Under Florida law, a new trial would be warranted if the jurors considered unauthorized material affecting their verdict. Sorry, y'all. I cannot breathe. Once Miss Benefield has established jury misconduct, we already went through that. We have to prove beyond a reasonable doubt that the error wasn't a contribution to the verdict. Cell phone during deliberation constitutes. Sorry, I got like it's probably so much information, but like mucus in my nose and it's really bothering me. Okay. The presence of the use of a cell phone in the jury room during deliberations is a clear instance of juror misconduct. The courts held that using a smartphone to access information not presented at trial was equivalent to bringing unauthorized material in the room. The court stated a dictionary is not one of the materials permitted to be taken in the jury room. By extension, a cell phone which provides access to vast amounts of information beyond the presented trial is equally impermissible. I don't know about that, y'all. I know y'all know you're mad at me. I don't know about that because he's saying that it was a flip phone, assuming that we're believing everything that hoodie guy says. It was a flip phone. And I don't know if y'all remember, I know some flip phones do have access to the internet, but I remember having a flip phone and we clicked on the internet button. We had to hurry up and turn it off because our parents didn't pay for internet. So in my head, flip phones don't have internet. Maybe they do now. And I mean, I guess they did back then. We just don't want to get in trouble for using it. I'm sorry, y'all, I'm making light of it. But it's not saying she necessarily accessed outside information. She just gave jury information. Was she asking for his opinion? I don't know. I didn't read this far, y'all. As far as the law is supporting it. By extension, and this is him making the assumption. This is not cited. This is not a cited law. He's just saying by extension, a cell phone which provides access to a vast amount of information beyond presented at trial is equally impermissible. Does not necessarily say that she accessed additional information. She was just giving out additional information. But you also can't talk to anybody about the trial. So I guess I think they should put that law in there then. I think they should put that one in there. The use of the cell phone during deliberation constitutes an objective act that compromises the integrity of the fact-finding process. As noted in the case, some objective act must have been committed by or in the presence of a jury or a juror, which compromise the integrity of the fact-finding process. The presence and use of a cell phone undoubtedly meets the criterion as it provided the jury with potential access to information not presented at trial. So we got to assume that they was looking at extra information. I don't know if I'm all the way there with them. I don't know. Unless they were specifically excluded from having their cell phone with them, then I don't know. And if they were specifically excluded from doing that, I think they should have put that in this. Because y'all got to give me all the rules. Talk to me like I'm dumb. I don't know what's going on. They probably wasn't allowed to have their cell phone, but nonetheless, I'll go on. Presumption of prejudice. Under Florida law, one juror misconduct is established. There is a rebuttable presumption of prejudice. The burden then shifts to the other side. In this case, the presence of the use of a cell phone during deliberations creates a probability that jury's decision-making process was influenced by unauthorized information. Wherefore, Ms. Benefield praised the following evidentiary hearing, wherein the court recalls the jury and allows them to be questioned by the parties. The court grant her a new motion. I don't know, y'all. I'm kind of with them, but also I want to poke holes. I want to poke holes in their story. I'll stop. For the juror thing, I'm kind of like on the rocker about whether they would have preempted her. I think it's easy to say, oh yeah, I would have preempted her if I found that out. But they also might have questioned her and she might have said, oh yeah, those were false allegations filed against me and they weren't even granted. That might, and then she's on the victim side because she filed a protective order first. So I don't know. I think that's interesting. And then for the cell phone thing, I want to know if there was a rule that they couldn't bring their cell phones, but there probably was a rule that they couldn't have their cell phones. But why not put it in here? Why not put it in here? Okay, I'm gonna move on because y'all know I get distracted. All right, let's see what the people got to say. Where we at with our likes now? We are at 53 likes, y'all. 7 more likes till we hit our like goal of 60 likes for the live stream. Okay? If you haven't hit the like button, please do. It does help us out in the algae. Let's see what the chat has to say. Stargazer Kawaii says, I feel like there have been so many jury misconduct allegations in the last 2 years because everything's on the internet. Everything's on the freaking internet. If it's ever being streamed, you're going to get an allegation of jury misconduct. Guaranteed, because they're freaking on YouTube. And if it wasn't being streamed, maybe that wouldn't have got back to them, you know? Julia 543 says, Stargazer Kawaii, I agree, but also the sample we have is probably not representative. Yeah, we're people on the internet that watch lawsuits, right? The ones that are streamed, that are popular, that have a lot of media coverage. That's what we're looking at. Chris Muller says, apparently she was both a victim and a perpetrator of DV. Yeah, exactly. She was on both sides, right? And again, we don't even know if the ones that were filed against her were actually granted. And the fact that she filed one 9 months later, it indicates to me, or that the husband filed, or the ex-husband filed one 9 months later, indicates to me that either the first one wasn't granted or it was granted for a very short time, which is still like you're found guilty of it. But still, no, because if she was found guilty of it, she probably wouldn't have had joint custody of their kid. So I'm leaning more towards at least the first one was denied. But, you know. Julia 543 says, women are ridiculously judgmental of other women. That is true. That is true. Tiny D says, not necessarily. Women are very judgmental of other women. That is true. I think that she was on both sides of it, though. And I think there was a lot of women jurors too, right? Destiny B said, to counter your point, a victim of DV might feel like their situation was worse if they survive. Ashley was just being too soft instead of believing her. Huh, I didn't think about that position. That makes sense. Kimmy says, DV victims won't automatically side with Ashley because they might weigh evidence against personal definition and threshold rather than the law. That is also true. That is also true. Stargazer Kawaii says, unfortunately, people lie all the time about abuse during divorce. Yeah. And so that's what I'm saying. The fact that they didn't tell us whether it was granted or not, I can't really say that she was guilty of doing it, you know? To say that she was that person, because the person could have easily met. Do you know how many cases I handle where people straight up lie to the judge's face? Man, it's crazy. So I would have really liked to see information of whether it was granted or not, or dropped, or what happened. Just like there was evidence during the trial that they voluntarily, mutually agreed to drop it, or they mutually agreed to stay away from each other. I would like to know whether there was a mutual agreement in that case, or if it was actually granted, because I think that would change. I think that would have changed even their preemptory challenge, right? Stargazer Kawaii says, unfortunately, people lie all the time about abuse during divorce. That does happen a lot. Island says, agree. It's messy, but I think you'd remember all of this. Yeah, that is. The thing is if she didn't do it and she wasn't found liable for it, because remember, these are civil cases, she might have forgot about it. She might be like, well, my husband accused me of doing these things, or my ex-husband accused me of doing these things that I didn't do. So technically, no, I haven't been, I haven't committed a crime against anyone. So, but also paying your son's bond. That one, they didn't really highlight that one, but that one is kind of, bad. Okay. Wire says all of these are just allegations. Yeah, they are allegations. That's what I said. They didn't really say that she was convicted of these things, or not convicted, because it was a DV thing. So she was liable for these things. The court found that, and I'm telling y'all, the burden of proof for domestic violence, at least in California, is really, really, really low. So if she really did do those things, the restraining order should have been granted against her. The protective order should have been granted against her. Julia 543 says, it is best when they point to a juror they did strike. It is best when they point to it. Yeah. Okay. Yeah. Like someone else had a similar situation and we got rid of them. Yeah, that makes sense. Stargazer Kawaii says, my mom was dragged into court by a boyfriend ex, claiming one of my mom's 2 sons assaulted her daughter. Unfortunately for her and my sister and I weren't boys and had boy nicknames. Oh, because they were just like, oh, they those boys hurt them, but whole time there are no boys to hurt someone. Is that what you're saying? Kimmy Lockett says, whoops, the doc didn't have any redactions and I don't. Oh, that was you. I'm sorry, Kimmy. I kind of put you on blast. I'm sorry about that. Kimmy Lockett says, whoops, the doc didn't have any redactions. I also know it's publicly available, but didn't want to put non-parties out there like that. So I'm the one who goofed and missed that one. No problem. No problem. Didn't mean to put you on blast. Julie, because I read the ones like before you redacted them. And I was like, it wasn't redacted there. And then I was like, oh, why did they redact this one? Julia 543 says, I thought victim in 2006. I thought victim in 2016, something with a son in 2014, and then allegations against her in 2003 and 2004. Let me go back. I think they all were, the ones against her were in 2003 and 2004. But I thought that let me go back. Where was that at? I could have misread it. Okay, yeah. Oh, yep, you're right. So she filed one of being a victim in 2016 with her living boyfriend. So she is a little bit closer on the victim side. I don't know. I mixed it up. I thought she was the one that filed it first, but it looks like she filed one later in time with a different guy, but she had two filed against her in 2003. You're right, Julia. Kimmy Locker says, yes to Julia. Petitions were filed against her in 2003, 2004, posted bond for her son's felony battery charge in 2014, and was a victim in 2016. Yes, you guys are right. Chris Mullen says she might have done it from the toilet. What? Who did what from the toilet? Warwick says people boo all the time in the chat, especially in Law and Crime. That's what I'm wondering too. But the fact that it came out, that would be the question. Was it a 5-1? Because they said they were hung. Was it a 5-1 or was it a 3-4? Like they could have been messing around. We don't know until they can question the jurors. And if the state asks the question to jurors too, the court will probably allow them to question the jurors. Julia 543. Says, I thought bailiff stayed outside the door, not inside. Nobody can know their discussions. That isn't on jury. Yeah. And was the bailiff listening through the door? I don't know, y'all, because I don't do jury trials. So I don't remember all the rules from when I was in law school. And so I don't know if the bailiff is in or out of the room. Because what if the jurors start fighting? Because sometimes jurors do get like very feisty. Island says, I thought so too. Like I said, I don't know the rules on that because I don't do jury trials. Julia said, when I had a grand jury duty, we never had anybody with us during our deliberations. And that does make sense. I just don't know off the top of my head. Chris Mullen says, it is possible that he was a troll who just happened to get it right. Coincidental, maybe. That is also possible, especially because they kept saying the same thing and like, look at me, look at me. It's very possible that it's a troll. That begs the question of, was it really 5-1 or was it some other type of hang, you know? Zoe B says, texting with a flip phone seems fishy, not easy to sneak a text on those. So yeah, like you have to be like, yeah, no, I don't agree with that fact. Like, that's hard to do. I don't know about that. I feel like, how did no one see them, or did they just not care? Kimmy Locker says, wasn't the jury older, though? So flip phone doesn't seem wild to me. Not gonna lie, you're probably right. But also, I think older people like easy things to do and not have to press the button 45 million times to get the letter that they're looking for. So that's interesting. I didn't think of that one. Chris Mullen says, oh, there are modern flip phones these days from Samsung that fold up. Okay, that's smart. Island says to Zoe B, I think it might be easier. It can be done by touch. Yeah, I know you can do that like on your actual phone, the touch buttons. Julia 543 says, John Smith and Zoe B. Oh, with a flip phone, I used to be able to text one-handed under my desk in high school. T9 was great with the dot on the 5. Know where your hand is. I think that was, I'm thinking T-Mobile, but he put T9. where they hand is most of the time. Yeah, no. And when you do it often, you can get really good at it. I'm not saying it's impossible, but I do think it'll be a little bit more sketchy. I don't know. Isla says, but if this happened, the juror was obviously discussing deliberations outside with people. Yes, exactly. No, I agree with you on that. But I was like, it doesn't mean they search things. My issue is with the defense highlighting that they could have searched things versus, or that they were asking for information or whatever, versus you should not have had a phone in there. If that was the rule, that should have been highlighted. Like, court said no phones in the deliberation room, or that it had to be off, or you had to hand it to the bailiff or whatever. I think that would have been a strong argument to start with, and then they could have gone to the next part. That's just my opinion. Julia 543 says, but she can ask him questions. Yeah, but they didn't say they asked questions. It just said that she gave information, allegedly. And Julia 543 says, oh, you are always not allowed to have a cell phone. And yes, and I think they should have started with that one. That's a stronger argument. The jurors are not allowed to have cell phones. That's the strongest argument. Just Stargazer Kawaii says, have they investigated the cell phone to see what she did with it? They don't even know who had the cell phone. They're calling it an unidentified juror. So they don't know who it is yet. So they want to be able to question the jury. What if it was juror 15? What if it was juror 15? They already want to get rid of that lady. Oh my gosh. YX says these comments look like coming from a kid. Definitely doesn't sound like a brother of an elder juror. That's an option too. That's possible too. Zoe B says older style flip phones, as in before Razors and first gen iPhones, is what I'm picturing. Why would they include the detail that it was a flip phone? That's what I'm picturing too. Something like that was super old. Kimmy Locker says to Zoe B, I also pictured an older flip phone. Maybe they included that detail as a way to explain how it was snuck in because it's smaller, easier to conceal. Again, assuming not true. I'm like, do they not have like pat down and stuff? And I would assume, like, obviously, my assumption is if you are sneaking a phone in as a woman, that phone is going in your boobs or under your boob. So to get that thing out, would be very obvious. Are you like all in your boob? I'm sorry, y'all. I'm making light of it. It's just crazy. Island said, it's also possible some internet rando was just saying stuff. Someone came into Danny On's chat claiming to be Sarah Boone's best friend. And people do it all the time. Right? And they could have just happened to get it right. Or that's why they need to question the jury to know what the hung jury was. What was the ratio? Chris Mullen says they're also presuming that she was on the prosecution side. She might have been one of the holdouts for guilty of a murder for all they know. Yeah, exactly. That is also the assumption, is that it affected the verdict because she voted. But she ended up voting that they were guilty, but also there was a holdout, right? So that's an interesting point to bring up. Chris Mullen says, I just have the most weird feeling in my life. Oh, that was weird. Chris Mullen says, I suspected that someone screen captured the chat and sent it to the lawyer. That's what I would imagine. Apparently, Law and Crime removed the chat. So I'm wondering if someone captured it and then passed that on. And then Law and Crime just deleted the evidence. That's not a good thing. Kimmy Locker says to Chris Mullen, do you know for sure Law and Crime removed the messages? I figured the brother deleted them when he realized they could cause issues, assuming it's true. In the documents filed to the court, they accuse Law and Crime of deleting it. I don't know. Can you? Yeah, I guess you can remove your own comments as they go, but after the stream is posted, can you do that? I don't know. Chris Mullen says to Kimmy Locker, no, I do not know for sure. I just saw it said somewhere that Law and Crime had deleted the messages. It was in the actual filed motions where it said it. At least that's where I saw it. Kimmy Locker says to Chris Mullen, yeah, the motion says the messages were removed, but I haven't seen claims about who removed them. They might exist, though. I certainly haven't seen everything. In the actual motion, to interview the jurors by the defense, it says that Law and Crime removed it. Isla says whoever was screenshotting them must have been quick. That's what I'm like, did this screenshot happen on the same day? Or did they go back and find that? Destin to be says, if it's unknown, all the more reason to yeet her from the jury. Yeah, I don't. Oh, like if you don't know if she was guilty or not. Yeah, I guess so. But I think they would have questioned her first. Chris Mullen says she might have messaged her brother from the toilet. Oh, okay. Like she was going in and out of the jury room with a cell phone. What I was going to say says, I'm so late. Did Bree not read Richard Gadd's declaration? That's where the tea was. I didn't read it because I'm tired, but I'm going to try to get it on maybe a pre-record this weekend. I say I'm going to do a lot of pre-records, and then the weekend comes and I can't do anything because I'm so exhausted from working. So I'll have to see. But no, I did not read his declaration. Julia 543 said, I'd rather see evidence that they used a preemptory strike against a different potential juror, yes, for any DV accusation than any evidence of being granted for or against the juror. Yeah, no, that makes sense. I agree with you as far as to say, look, we got rid of a case involving DV because we don't want that kind of personal experience to play a part. But a lot of times when people do have this personal experience playing a part, they don't always get kicked off the jury. They're asked like, hey, can you be impartial despite you going through that? And they say yes. And sometimes attorneys keep them on. Or they'll ask like different questions, not that straightforward, but they'll ask different questions to determine whether that person will be biased or not. Kimmy Locker says, stop. I would lose my mind if Juror 15 had the phone. That's I want to know if it's the same person. They said it's a lady. Phoenix Wallace says, all hell the boob person. Yes. Literally. It would be so obvious. I don't see how else they would have been able to get it in the July heat. We're not wearing jackets, right? Julia 543 says, you can have a sweater with pockets, and if good at texting in a pocket, good at texting in the pockets can do it easily. That is also true. That people used to do it in high school for sure. But I'm also thinking it was too hot to have a jacket on that day. I could be wrong. Zoe B says screenshots can be a product of arts and crafts. Just ask Laura Owen. She's great at creating pictures of doctor documents. That is a thing. That is a thing we've just witnessed on YouTube. Island said, did someone delete the original messages, or did Law and Crime disable the chat replay? I don't know. I don't know the answer to that. And Julia 543 says, you can remove your comments when you watch with live chat replay. Oh, so even on the replay, you can still remove it? Chris Mullen says, yes, as far as I can recall, you can delete your messages at any time during or after the live stream. Interesting. 81CV41 says, Wayback Machine is your friend. to try to find the comments. Kimmy Lockett says, the motion to interview says the prompt removal of these comments from the verdict watch on. Oh, okay. I might have read it wrong. On the Law and Crime Network YouTube channel, but I didn't interpret that as Law and Crime doing it. I mean, it's possible. I thought that's what I read, but I was also reading a lot of things. Julia 543 says, Chris Mullen, you can delete during the stream if you scroll up that far. Island says some jury rooms have single occupancy bathrooms in them. No, that happened in Murdoch. No, that makes sense. Oh my gosh. I'm going with it's Juror 15 if anybody. It's Juror 15 if anybody. That's what I'm going with. Don't quote me on it, y'all. I'm just talking. Julia 543 says, no pat downs of jury, very much lectured to not have cell phones, have to lock it up in lockers with your purse and stuff. And so if you don't do it, they'd never find it, essentially. Kimmy Locker says, yeah, IDK is speculation and shade tonight. Yeah, exactly. Julia 543 says, sometimes the hotter it is outside, the more air conditioning gets cranked up. That is also true. I did think of that, but I didn't want to talk about that one, Julia. Okay, y'all. I'm out of energy. I don't know what I'm going to have for y'all this weekend, if I can get anything done, because there's like a wedding and then I'm supposed to go see my mom. And then I'm also tired and I need to clean my house and I need to put up decorations and all kinds of stuff. But excuse me, I would try to get to something this week. we will have an answer. Hopefully, at least the hearing will go forward on September 3rd on the baby Reindeer motion to dismiss, motion to strike the pleadings. That case might get shut out. So we're probably going to cover that next week. And then I'm going to be looking deeper into Donald Adelson and what's going on with that case. And hopefully to get something out before then. I have not gotten around to posting my little court stories for y'all on YouTube, but I'm going to get around to those as well. So I just got to find the energy. My trial season is slowing down, but still very much alive. Definitely planning my calendar a little bit different for work because that drained me like crazy. Julia 543 says no, we'll see you Tuesday. I normally do Thursday now. I'll normally do Thursday, but we might have to come on Tuesday, I guess. We might have to come on Tuesday. Zoe B says, oh, is the clerk of court Becky from Murdoch Juror 15 plot twist? Not moving whole counties. Not moving whole counties. Okay. I might be able to do a Tuesday. What do I got on Tuesday? Let's see what I got on my calendar. Because the 3rd, oh, did you mean like no? Or no, you said you'll see me on Tuesday. Okay. I thought I read it wrong. The 3rd, I believe, is Tuesday. Right? Yep. 3rd is Tuesday. So we might, if we get the actual orders that day, we might be able to stream on Tuesday to cover that. As OEB said, Bree, enjoy a time with family and take time to yourself. I know, but I need to push out the content. Thank you very much. Tiny D saying 59 likes, that's close enough. Can we play the animation, I'm guessing? Julia 543 said just Thursday. Okay, we'll see you Thursday. Julia says trying not to pressure you. No, Thursday. Okay, that works. That works. The other thing is then I put too many things on the docket and then I'm super tired by the end of it. So I'm going to go ahead, since we're at 59 likes, it's showing 58 on my end, but we're going to play the animation anyways because it's fun and it's the end of the stream. So if you don't know, our Like Go animation has a really big boom in the beginning. So if you are sensitive to sound, this is the time to turn your volume down. Oh, that was rhyming. That was rhyming. I'm going to play it in 3, 2, 1. All right. Shout out to the BriHive. Thank you very much for getting close to the like goal. Two less. But if you haven't hit the like button, please do. It does help, but it does help us out in the algorithm. It does help us get more friends. And we are, of course, trying to grow the channel. I know that you guys are seeing 60. Oh, no, I finally see 60. So yay, we did it. So we're going to play the other one just because. And this one has a loud boom somewhere in the middle. So here we go. Yeah, so we got 2 like goals for the night. Shout out to us. Shout out to us. Okay. Anyways, I hope everyone has a wonderful weekend and I will see y'all all on the next live stream. Bye.